Rise. All persons having business before the Honorable Associate Judges, now provide for the fifth time your court appeals, draw near and give your attention. God save the United States and is on the court. This on the court, the gavel session, please be seated and come forward.
Good morning and welcome to the District of Columbia Court of Appeals. We are back in person and it is lovely to see you all today here in the courtroom. This is also our first hybrid oral argument, so you'll see we're on the screen and we're in person. So bear with us, we might have some technical glitches, but what that means for the first case is that one of our litigants is going to be appearing remotely, and then the government will be here in person, is here in person. Thank you very much. Nice to see you. So you've also noticed that we walked in with masks on, but we took them off. We decided that we wanted to make sure that the litigants could see who's talking, even if they're on the screen. So it's really for comprehension and clarity of the proceedings that we have our masks off. So thank you very much for being here. We'll get started. We have three cases on our calendar today. The first case is 19 CF 1054, LARRICO and Williams versus the United States. Ms. Vanderhorst. You are muted.
Good morning, Your Honor.
Good morning. Can you introduce yourself for the record and let us know how much time you would like for rebuttal?
May it please the court, I am Geneva Vanderhorst, attorney for the appellant. Good morning to the court. We would like to reserve 4 minutes for rebuttal.
Thank you. Whenever you're ready, you may begin.
Thank you. In this case, the trial court failed to grant the appellant's motion to suppress, where the police acted unreasonably in an uncorroborated anonymous text tip that provided no information to assess the reliability of the tipster. The reason why the anonymous text and the tipster are important to this case is because the trial court considered it to be corroborating the evidence in the case when deciding to not grant the motion to suppress. In both of the briefs, the court will note that there were two motions at trial. One was the motion to suppress, which is the only one that we're really dealing with. But from the second motion, the trial court also considered some of the evidence, but did not grant that motion. And so I want to also
Can I ask you just to zero in on that. So in the suppression hearing proper, there was testimony and there were some exhibits that were introduced into evidence. And I understand from your brief and from what you just said that you think that the trial court considered more than just those materials, and that we appropriately should as well. And can I just make sure exactly what else you think we should be considering, if you do think we should be considering things other than the testimony that was within the confines of the suppression hearing and the exhibits that were introduced during that hearing? What else do you think we should consider?
Only those things, Your Honor, the testimony and the evidence that was considered.
So you're not arguing that we should consider any of the, there's a lot of other information that was floating around. There were representations of fact that are contained in the motions and oppositions to in the context of the suppression hearing. There was testimony and exhibits introduced and or referred to in connection with the Brady motion. There were, I think, some factual representations that were made by parties during argument on the motion to suppress. You're saying we should not consider any of that and we should limit ourselves to the four corners of the suppression hearing. Is that correct?
To be clear, Your Honor, the trial court considered the facts that in context of the Brady motion, but not the Brady motion itself when deciding to not grant the motion to suppress in this matter.
So just
there
to be clear, are you saying that we should take into account the evidence that was introduced and that the trial court did take into account the evidence that was introduced as, in connection with the Brady motion as part of the evidentiary record that we should be considering in reviewing the trial court suppression ruling?
Correct, Your Honor. Just the factual parts that as the trial court did. Those are the factual context parts that we'd ask the court to consider.
Excuse me for interrupting, but that leads me to another question. You said we should consider what the trial court did consider. The trial court said, look, I think this anonymous tip has been corroborated for 4 reasons. And among those reasons, it mentioned that the detectives had viewed the CCTV footage.
Mhm.
But the trial court makes no findings about what the detectives saw on the CCTV footage. And quite understandably, I would think, because there's no testimony about what the detectives saw on the CCTV footage. So it would have been difficult for the trial court to make findings. So where does that leave us? There is references to the CCTV footage on the record. It appears that the trial court saw the CCTV footage, but the court doesn't say what the CCTV footage shows, and we don't know what the detectives saw.
Your Honor, the only witness for the motion was the arresting officer, Mr. Ryan Sullivan. He was not a detective at the time of his testimony. If the court looks through the appellant's brief, we detailed quite a bit of the cross-examination where the trial attorney reviewed the CCTV footage, and the government and both the appellant's attorney had an opportunity to ask him questions on that. So his responses on what was visible in that footage is what I believe the court should be able to consider. So
And
you are right that
am I right in recalling that in the confines of the suppression hearing, there was hearsay testimony from Officer Sullivan that the homicide detectives saw? I think that they viewed CCTV footage from the gas station, and that they saw a silver sedan in that footage. Is that accurate, or am I may be misallocating testimony to proceeding?
To be clear, Officer Sullivan made 2 representations regarding that car. One was that he was informed that what they saw was a silver sedan, and later
Who saw?
Officer, what the detective saw.
Was he even able to say that?
He testified about what information he relied on, and
Right. He gives hearsay and says, I was told later that somebody, I don't know who, and I don't know when, looked at CCTV footage. And then, as Judge McLeese describes on page 86 of the transcript, he is asked, well, what did they learn? What did you learn that they saw? And he says, well, I was told they saw a silver sedan in the area of the shooting.
More accurately, Your Honor, the trial counsel was able to retrieve from Officer Sullivan that they identified it as the sedan as a silver Lexus, which is not what Appellant Williams was found in on the night of the arrest.
That's after, right? That I don't think there's any testimony from the police officer that they knew that the car was a silver Lexus before they arrested your client. There's no testimony one way or another. We don't know what they saw on the CCTV footage other than there is a silver car. But we don't know what the CCTV footage shows because there's no findings.
We would-
And right,
we
and we
would-
don't know what the detectives saw because there's no testimony about what they saw other than some vague testimony about a silver sedan in the area.
There is
I guess, well, let's
testimony-
start there. Do you think testimony that information the police have that there is a car in the area matching this description is corroboration of an anonymous tip?
Well, I want to be clear because Officer Sullivan did say that there were detectives. Who
I'd like
showed
an
up
answer
on
to
this-
my question. Do you think that if police have received an anonymous tip that a silver sedan is involved in a shooting, and then they get CCTV footage showing a silver sedan in the area of the shooting, is that adequate corroboration of an anonymous tip that it's the same silver sedan?
Not in this case, Your Honor. Well, if I may, it's important to understand that the tip in this case was not a text message as we would think of it. It actually is similar to a person who calls a hotline, another person writes out the message. And the fact of the message gets text to the detective. So the
Counsel,
detective
you're
doesn't
telling us
actually-
that. Can I ask
Where
a
is-
question? Well, how do we know that? You're explaining to us some information about this tip. Was that in evidence
both-
somewhere? Or-
In both of the briefs, Your Honor, both the government and I made reference to the description by Officer Sullivan of what the text tip was. And that was his-
Officer Sullivan doesn't say that at the suppression hearing, I don't think. And this is part of the problem, is that there's a lot of references in the briefs to things that people said at various points in times during this case, but that wasn't actually evidence at the suppression hearing. Lawyers said different things at different times, and I think the explanation of the text tip comes at a completely different proceeding months before the suppression hearing. At least that's according to the citation in the briefs. So where do we have that in evidence? And should we be considering things that lawyers are just saying at any time during the proceedings?
I don't believe, Your Honor, it's in the argument. I believe it was in the cross-examination of Officer Sullivan at the preliminary hearing that he makes that description.
So just to be, I thought your answer to some earlier questions didn't really embrace going back so far as to testimony at the preliminary hearing as part of what we should be considering. But can I ask you just to zero in on the CCTV footage? And that's a somewhat generic term because there were multiple different, I gather, not so clear that that was evidence in this proceeding, but according to the parties at various points, I gather that there is, the police ultimately got a number of different pieces of surveillance, CCTV footage, and some of it may depict more or less detail, and it was gathered at various times. But there was, in connection with the Brady motion, an exhibit that I gather appears to have included the CCTV footage that the investigators may have looked at on the morning of the shooting, but also seems to have included some other CCTV footage that appears to have been gathered later and may or may not show additional detail that may or may not be consistent with the appearance of the car your client was in. Is it your position that exhibit from the Brady proceeding is part of the record for the suppression hearing that was considered by the trial court and is part of the record that we should be considering in deciding this motion? Is that in or out of the trial record and our appellate record with respect to the ruling that is at issue in this appeal?
It is based on Officer Sullivan's response to questions as he reviewed the CCTV footage before the court.
Generally, that a witness refers to footage or some other material doesn't make that material itself part of our record. That's just testimony about whatever might be on that exhibit. So I'm not sure that would get it in. And I ask my question in part because there was some discussion on that question about whether that exhibit from the Brady proceeding should or should not be considered in the suppression context. And it seemed to me that both parties at various points took, they tended to disagree, but they also changed over time, so that there was a period when the trial defense attorney wanted it in, and the United States was suggesting it was out. And then the next day, at the time of the ruling, it seemed like maybe parties had flipped their positions. So I found it. It wasn't obvious to me what the answer to the question I'm asking you is, but you're saying you think it is something that is part of our record, that that exhibit should be viewed as part of the record that we need to consider in resolving this motion.
It was submitted and admitted by the court. It was submitted, I believe, by the government and admitted by the trial court.
Well, in the Brady proceeding, or do you think it was admitted in connection with the suppression hearing?
For purposes of the suppression hearing, yes.
Where did that happen?
And as Officer Sullivan testified, his testimony was based on reviewing the CCTV footage from the gas station for both the cross and for the argument.
You're losing me a little bit, because assuming that's true, that doesn't seem to cause the that footage to be admitted. It's just a witness testified about some footage. It seems to me quite a different thing for the footage to be admitted into evidence itself.
I agree, Your Honor,
There
but
is a point in the transcript, counsel, where defense counsel asks the court to review it, to consider it. But I don't see any place in the transcript where the court says that it is or it isn't.
Your Honor, I actually believe it was submitted.
And there's also, not to interrupt, but we don't have the CCTV footage. It has not been provided to this court in the course of this appeal.
Your Honor, I believe.
Sorry to pile on, but could you also answer as part of that? Wasn't Officer Sullivan testifying not that he reviewed the CCTV footage himself, but to what another officer reviewed?
The CCTV footage, I believe, was submitted by a motion from the government on supplementary materials. So I believe that it was submitted. I'm not sure why the court does not have it. And as to Officer Sullivan's information.
Just to clarify that piece of it, there was information provided to us by way of a motion to supplement, but that was body worn camera footage and other footage relating to the stop of your client. I don't believe, unless I'm misrecollecting, that the United States provided to us in those supplementary materials any of the surveillance footage.
Your Honor, you're right. It did include the body worn camera footage from Officer Sullivan. It was my understanding that it also included the CCTV footage as well. I guess counsel and I can make an adjustment to the record if the court wants to have that provided, as it was to the trial court.
What's tricky about that, I'm not sure what the court will want about that. In part, what the questions that we've been asking are trying to determine whether that was in evidence for this purpose in the trial court. If it wasn't, then we really probably shouldn't see it. Whereas if it was, then we might well need to see it. So the answer to the question of whether we would want to see it depends on some of the answers to some of the questions we're asking about whether it was in front of the trial court for this purpose. It clearly was at least viewed. I was a little unsure whether it got formally admitted in the Brady proceeding, but it was definitely viewed by the trial court in connection with the Brady proceeding. So it was, I think, sort of de facto in evidence in connection with the Brady motion, but it's a lot blurrier to me whether it was it was understood by everybody, including the trial court, most importantly, to be in front of the trial court for purposes of the suppression hearing rule.
And if I may, Your Honor, when the trial court considered the distinction between the description of it simply being a silver sedan that was seen on that footage versus the clearer testimony that it was a silver Lexus that had a back panel window that was out and covered with a white bag. And under that, it was a huge dent, which made it clearly distinctive from the car that my client was located in, which was a silver Infiniti. It brought into question the reliability of the tipster, who gave a license plate that matched the Infiniti, but did not match the Lexus and did not match the description of the car that was seen at the earlier shooting, completely unrelated to Mr. LARRICO Williams. That was the information that Officer Sullivan relied on when he made the stop. And to be clear, if we review his body-worn camera
I'm sorry,
footage.
I'm not sure I understood what you just said. You described a bunch of information. Again, I'm not sure any of it was directly in evidence in the suppression hearing, as some of it was definitely in front of the court in connection with the Brady motion, about the differences in the car depicted in some of the surveillance footage and the car that your client was stopped in. But you said that was, you recounted all that information in that what's depicted in that body-worn camera, in that surveillance footage. And I thought I heard you say that was the information that Officer Sullivan relied upon in making the stop. And that's where I got confused, because it seems, if we're going to take into account the information we learned in other filings and in evidence introduced in other proceedings on other motions, that some of that surveillance camera footage was not available to the police, well, I don't know about available, but discovered by the police until after the stop in this case, and therefore couldn't have been anything that Officer Sullivan was relying upon in making the stop. So am I misunderstanding something?
I was going to offer up some clarity, Your Honor. When Officer Sullivan, from his perspective, made a stop, his body-worn camera shows that the Infiniti was not obstructing traffic, which was the basis for Officer Sullivan saying that it was a legal stop. His body-worn camera contradicted his testimony because it showed and said that the car was not obstructing traffic and it was properly parked. So his basis for saying that he made the stop because it was obstructing traffic is not a legal stop. It's not a legal basis.
I thought, Ms. Vanderhorst, we were talking about the CCTV footage, but I think we've gone around a bit on this, and you are out of time at the moment. So unless either of my colleagues have more questions for you, we'll hear from the government now, and we'll let you say a little bit more in rebuttal after the government.
Thank you.
If you could, yeah, thank you for muting.
Thank you, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. Your Honors, just to hopefully clarify what I can about what was in evidence and not. At page 147 on August 19th, which is the end of the hearing where the court decided the Brady hearing at the beginning of the day and then entertained most of the arguments on the suppression hearing. At the very end, Ms. Lotzi indicated that she was going to take exhibits off her USB drive that had 2 exhibits that had been admitted, which she is saying were included screenshots of the silver Lexus and the video clip created by the government. It's not clear, as I went through the record, either whether or not those exhibits actually ended up being admitted in the suppression hearing. It did seem as Judge McLeese noted that by the next day, people seemed to accept that a portion of what was in that video compilation was gas station video, apparently from the 23rd. of December. It was never a government exhibit at either the Brady hearing or the suppression hearing, this video compilation.
Here's my problem. Let's assume for the sake of argument that the court sees some pictures, stills or video excerpts from CCTV footage. We don't know what the court saw. We don't have any findings from the court about what the court saw. And more importantly, we don't know what it doesn't actually matter what the CCTV footage shows at the suppression hearing. What matters is what the government knew after they got the anonymous tip and before they arrested Mr. Williams, right?
Right.
And that's what we don't know, right? We have no idea what the other police officers, detectives, whoever they were, because Officer Sullivan can't identify them, doesn't know who he spoke to learn that somebody at some point in time had seen the CCTV footage. He doesn't tell us, right? There are two questions that I see in the transcript on page, I believe it's 86, right? And he is asked, right, what did you learn about what the investigators saw when they looked at the footage? And he says, well, I learned the investigators pulled the footage from the actual gas station where the shooting occurred and observed a silver sedan in the area right around the time of the shooting. So he gives that much information,
Right.
that a silver sedan is seen in the area. Don't know what time, don't know what in the area means.
Well,
And then there's a follow-up question. What did the CCTV footage show? It showed a sedan circling the area, right? So then he's just talking about what it showed, and then he's asked for more detail, and he says he can't remember. And that's all we have as far as I can tell. And that seems like pretty thin stuff as far as corroboration, even if we take it on its face. And then we also have floating around in the record this information that the CCTV footage actually shows quite a bit more, potentially shows that the car is not, an Infiniti, it's a Lexus, potentially shows that the car is damaged. But whatever, put that aside, we don't know what the corroboration was. We just know that someone is testifying that some viewing of CCTV footage was done. And that seems inadequate to me. And I'm wondering why the government thinks that's sufficient.
because it's my understanding was that and I'm just reviewing Officer Sullivan's testimony again, he's saying that the investigators, and he's saying that they're homicide investigators, they pulled the footage from the actual gas station. So that's actually very important. And my understanding in reading that second question is essentially, it's not the specific question, but it indicates that this is additional information that the homicide investigators passed on to him about what he had viewed. But the key point is that is the actual gas station footage. That's different from all this information that was shown in this compilation of videos in the Brady hearing that included additional footage that was obtained from different cameras on the 27th of December.
Well, you're telling us a lot of things now. It would help if you're going to refer to something that actually wasn't in evidence in the proceeding, if you flag that for us, because some of what you just said, I don't think is in evidence in the proceeding. And you were going to, that's just a comment. My question is, you said you started by saying you were going to try to shed some clarity on a question of what was with respect to the surveillance footage generally, whether it was or was not in front of the trial court. And you started making some comments on the topic, but I never got a bottom line. And so what is your position? For purposes of the record that was created in the trial court, is the CCTV footage in evidence and therefore part of what we need to be considering, or is it not in evidence?
It's just unclear to me, Your Honor, but the clarification that I know I can make is that it was a defense exhibit.
So you don't have, you don't know, the position of the United States is, we don't know whether that was or was not in evidence.
It's just not clear to me. I looked and I just can't tell. There's the comment by Ms. Lotzi on the page 147 of the 19th, where she's saying that she's going to put items on a USB drive.
Now, the trial court in its ruling says at one point there, when listing what the trial court viewed as corroboration, talks about the investigation of the CCTV footage, and says, while I agree with Ms. Lotzi, defense counsel, trial defense counsel, there's some insufficiencies about that. Was there any evidence, if we're really focused on what was formally admitted in the suppression hearing and what was testified to in the confines of the suppression hearing, was there any evidence about those insufficiencies, or does that seem to imply that the trial court was considering either the footage it had viewed or all the various representations of the parties in various filings or in court, or maybe also testimony in the early proceeding?
Sorry, Your Honor.
No, that's fine.
It seemed to be a combination, when he was saying insufficiencies, was a combination of whatever Ms. Lotzi had admitted in the Brady motion, plus arguments that the parties made, particularly the government was arguing that what the police would have known of and seen on the 23rd before the stop was just a silver sedan. They didn't have this additional information about it being a Lexus.
Can I ask you if
so forth, with damage until the 27th.
Let me ask you a hypothetical, which assume, which may well not be the case, so I'm not suggesting it is the case, but imagine that if the trial judge had focused in and been asked to make a finding about what information was known to the homicide investigators before the stop here, and had said, oh, it's only this footage from the gas station, and found that as a fact, and then had decided to make factual determination about what was depicted there, and had looked at it and said, well, it's not inconsistent with Officer Sullivan's testimony. It does show a silver sedan, but I look at that and I can tell it's a damage. It's got all this damage that apparently was reflected in some of the other camera footage. Maybe this too, I don't know. And I can tell it's not a Infiniti, it's a Lexus. Assume that that's the finding that someone might make, having looked only at that footage, or only at that footage plus whatever other footage was available to and viewed by the investigators before the stop. Do you agree that under the collective knowledge doctrine, that would all be kind of information that would tend to negate articulable suspicion to stop the car that was stopped here?
No, I don't think it would negate articulable suspicion to stop the car, because obviously the car doesn't have to be the exact car.
Well, my question is poorly worded. What I mean is, you might agree that although it tends to subtract from the overall amount of suspicion, there was still enough. But do you agree that it would be taken into account, and to the extent it tended to undermine articulable suspicion, it would have to be considered?
I guess my only point that I take issue with that is, would it be, if the court says, I'm viewing this video and I see damage and I've decided that it's a silver Lexus, that's different than a homicide investigator looking at that video and saying, I see clear damage.
You're quite, that's a very fair correction. And so that's a very fair correction. So let me ask it slightly differently, because I agree that's a very fair point. If the trial court looked at it and said, I don't think a reasonable officer could view that as corroborative of the tip, I think it is contradictory to the tip, because the tip is about one particular make of a car. This is a different one. I mean, worst case scenario for the United States, I can see the license plate. I myself, when I look at it, I can see the license plate. It's not the same license plate. But you're quite right that the issue would not be what the trial court's personal conclusions was, but more what the trial court thought a reasonable officer could conclude from viewing the video. I agree with that. But with that correction, do you agree that that would have to be taken into account, as it tended to undermine to the extent it did, or add to the extent it did, whether the legality of the stop of Mr. Williams.
Yes, I think both would have to be taken into account and viewed, as your honor says, in the views of a reasonable police officer in that situation. But of course, that wasn't the case here. What the officer
Well, I
Sullivan
actually don't know. I
testified
have
to.
no idea whether that's the case or not. That's the difficulty.
My understanding of Officer Sullivan's testimony, and I want to make clear, just in contrast to what defense counsel just said, there was no testimony by Officer Sullivan that the police officers who reviewed the camera footage from the gas station saw a silver Lexus with damage. The testimony by Officer Sullivan, as Judge Easterly noted, was that Officer Sullivan later learned that homicide investigators had retrieved CCTV footage from the King gas station and saw, quote, a silver sedan in the area right around the time of the shooting. And the footage showed that silver sedan circle the block, come back and pass by slowly the SUV where the victim was shot. So based on that information and that proffer of what the homicide investigators had done, that gives you corroboration of the tip.
Let's assume that a hearsay report of viewing a silver sedan in the neighborhood, no time is given, right? You're saying, well, you can identify it as the CCTV footage from the gas station where the shooting is, but there's no time provided. And this arrest happens, hours later. But let's assume for the sake of argument that substantively would be sufficient corroboration. Does it matter that he doesn't know who told him this or when, right? That this hearsay that he is providing, right? The government has chosen not to put on the law enforcement officers who actually did the corroboration and looked at the CCTV footage so that they could be asked exactly what they saw, right? And what they inferred from that. So the government has decided to put on a hearsay witness who doesn't remember who he talked to or when. And my understanding is, while hearsay is admissible in a suppression hearing, it has to be reliable hearsay. And if you don't know who the speaker is or when they spoke to you, is that reliable?
I don't think that's a problem, Your Honor. My recollection is that he learned the information about the CC footage. So he couldn't remember specifically when, but it was after the stop. And he didn't know the specific.
Well, right. I
name
mean,
of
it's
the
after,
person, but it
it's
was
after the
homicide
stop and it's before
investigators.
the suppression hearing, but goodness knows when and or
I
who.
don't-
I mean, it just doesn't really inspire confidence, right? When we say you need an anonymous tip to be corroborated, because anyone could say, hey, this car that is the make and model of Judge McLeese's car was involved in a shooting, right? I could describe it. Well, I can't describe it because I'm not a car person, but if I were, I could tell you, I know he's got a Wagmore Bark Less bumper sticker on his car. And I could say that and say that car was involved in a shooting. But, we don't really want police to go out and stop Judge McLeese on the street and investigate him for being involved in an AWIC or a homicide just on the basis of that. We want some corroboration. And so, you could say, well, somebody told me later that they pulled CCTV footage of this car with this bumper sticker, but I don't know who I talked to or when they said that. And is that the kind of corroboration we're looking for a tip?
I think that would go to the
sounds-
weight of the corroboration, but Your Honor, I think the important thing here is that corroboration was done before the stop was made. It's not as important when Officer Sullivan learned of
But
that
how-
information because of the collective knowledge doctrine.
But the fact that he can't give any detail, I mean, it just sounds like the police know that they have to put on corroboration, but they're not willing, or the government knows it has to put on corroboration, but it's not willing to actually put on the corroboration. It just puts on the person who says that there was corroboration.
But of course, the hearsay
it's
evidence
very,
is allowed in the
very-
suppression hearing. And of course, he
is,
is
but that
vague
gets to
about
my-
when it was spoken to, but what is not unclear is that this corroboration occurred before the stop. And that hearsay is allowed and that the collective knowledge doctrine would allow that to be taken into consideration.
If it's reliable hearsay.
What's the limit of the collective knowledge doctrine? Just because they're both MPD officers, if this person can't even, if Officer Sullivan can't even identify the investigator, inspector, officer that made this corroboration, like where do we draw the line there?
Well, you would draw the line differently than here because what is clear is that there's this investigation occurring after the homicide occurs, and that in this case, there is additional corroboration by the fact that the car with the exact license plate, make and model of the lookout over the simulcast is within the block of the homicide itself, less than 8 hours afterwards.
But that's not the kind of
that's-
corroboration we're looking for, right? It has to be corroboration that ties you to the criminality, and cars travel roads, right?
Right.
And
right.
people go to gas stations. And there are lots of silver sedans on the street. So,
Right, but of course, the tip here was this particular silver sedan with the make, model, same license plate. There is officer,
and I get back to Judge McLeese and his bumper
Testimony.
sticker. I could give very specific information identifying a vehicle.
the criminality
And the
here
fact that
is-
someone sees the car in the location that I said that it was, isn't corroboration that that car is involved in criminal activity.
We believe the corroboration is through Officer Sullivan's testimony about what he was told by homicide investigators who had retrieved the footage from the King gas station. So he knows where to answer Judge Howard's question, he knows where the video footage was pulled from. He knows homicide investigators pulled that footage and reviewed it and saw the silver sedan in the area of the shooting, right around the time of the shooting. He didn't get into minutes, but he did say it was right around the time of the shooting.
Can
And
I
that it
ask you
saw
about-
them pass by essentially the SUV where the victim was found.
Can I ask you about some of the other corroboration that the trial court relied upon, and I
Yes,
think the
Your Honor.
United States relies upon in its brief, which was the conduct of Mr. Williams after the stop. Later in the incident. And the way I just said it, after the stop, leads me to pose a question, which is, when do you think the stop occurred?
I think the stop occurred when the police pulled up behind him with their lights and
So to the extent that
And then-
we're trying to figure out whether there was articulable suspicion for that stop, it seems like the trial court may have stepped amiss in taking as corroboration the conduct of Mr. Williams after that stop. Do you agree that that isn't relevant to the legality of the stop if the stop preceded that conduct?
yes, I found that a little bit strange because we do believe the stop had occurred before he, for instance, started refusing police orders to get out of the car and so
So just
forth.
because you agree that the trial court, that is not corroboration that we should be considering because it occurred after the stop.
I don't think it's corroboration to support reasonable articulable suspicion for the stop of the car. To the extent that did provide additional reasonable articulable suspicion had it been needed to remove him from the car and then of course his behavior supported his probable cause for arrest for failure to obey an order. But of course, Your Honor knows that the police, once they made that stop, didn't have to have additional criminal information to have Mr. Williams removed from the car. I just think that given what the police knew by the time of the stop, hold that there was sufficient corroboration of the information about the Infinity for the police officers to have reasonable articulable suspicion for this car, which is of course much lower than probable cause. And the point is that it was a silver sedan, and at that point, the officers were even careful before they stopped the car to make sure that they had the right lookout information, calling back to the station to make sure that they had the proper information before the stop. So this is definitely not a situation where they're just willy-nilly pulling over any car with no corroboration. And for those reasons, we believe the decision of the trial court should be affirmed.
Thank you.
Thank you,
Thank
Your
you, Ms.
Honors.
Kelly. It's very good to see you in court. All right, Ms. Vanderhorst, we'll hear from you again, just a few minutes on rebuttal, and you need to unmute yourself.
Thank you, Your Honor. If I may, the court initiated a question to government counsel as to Mr. Sullivan's reference that he did not know where he got the information. That is accurate when he's being questioned by the government at that hearing, but I'd invite the court to review the lengthy cross-examination by the trial counsel of Mr. Sullivan, because in the cross-examination, he does give information on where he got that from. Specifically, he noted that he was in error when he testified earlier that he got the tip from hearing it at roll call, and said that he actually got it, the lookout came from detectives, not the roll call. And that's August 19th, 2019 transcript, pages 90 to 91 in cross-examination. And immediately after, he also says that it was Detective Devlin who told him about the CCTV footage from the gas station. So he did have that information on site. And the reference to Detective Devlin in his testimony is also August 19, 2019 transcript page.
I'm looking at page 91 of the transcript, and he says there was a Detective Devlin there. I don't know where there is. And the question is, so was it Detective Devlin that you spoke with regarding the CCTV footage that they looked at? No, I didn't speak with him at the time about that.
I believe,
Misunderstanding what you're saying, I thought you just attributed his conversation about the CCTV footage to Detective Devlin, but he's saying he didn't speak to him.
he goes back and forth a bit in cross-examination, but there is a point where he's talking about the CCTV
It follows up
footage.
next. When did you first learn any information at all about the CCTV footage? It was sometime after. I can't recall specifically when, like a day later, 2 days later, a week, a month. I don't know specifically when the information about the CCTV footage became part of my knowledge. I don't remember when that was. Okay, nor can you say with any certainty who it was that shared that information with you? No. Should I be looking at a different part of the transcript?
Your Honor, I believe it goes for about 3 pages where he goes back and forth. But I just wanted to note.
You can review it. I'll let you continue with your summary remarks.
I just wanted to note that in cross-examination, there's many times when he refers to his testimony, his initial testimony, but upon reviewing his own body-worn camera and being cross-examined on that, he does recall information that he did not say previously. And the court can make of that what it is in terms of his own reliability. But I would note that the cross-examination has much more detailed information in it than what he initially presents. And so it causes an issue as to whether the information he provides, first of all, is reliable.
Ms. Vanderhorst, it sounds like you're asking us to look at his cross and look at his direct and make some sort of credibility assessment, but we wouldn't do that. We certainly can look back at the transcript and see what it says or doesn't say, but those credibility findings need to be made by the trial court, no?
I understand that, Your Honor, and that's not what I'm asking the court to consider. What I'm asking the court to consider is that there is a lot of missing information, if you will, on what Officer Sullivan is able to provide, and that it goes to what his state of mind, or I'm sorry, it goes to his intent when he was stopping Mr. Williams. And so I wanted to simply ask the court to consider that when Mr. Sullivan makes his observations on Mr. LARRICO's Williams's actions, that it's well, I'll give it a court an example. There's a
Ms.
point where
Vanderhorst, you're running up against your time. We gave you 4 minutes for a rebuttal, so I'll let you make this observation and then I think you need to sum up.
there's a point where he says that Mr. Williams has stiffened his body and is resisting arrest simply by stepping out of the car. I would invite the court, if you're sitting, to consider that when you're sitting in a driving seat or simply sitting now, and you lift your left foot to step out of a car on the driver's side, your body instinctively is going to move to the right side. His observations of Mr. Williams and the descriptions that he makes have a certain bias to them. And I would invite the court to consider all of the information, not just his testimony, but the body-worn camera as well, because it gives a much more objective perspective, and it was considered by the trial court. I believe that's my time, Your Honor.
Thank you, Ms. Vanderhorst. Thank you again to both you and to Ms. Kelly. We appreciate your argument and the case will be submitted.
Thank you.
The next case on our calendar this morning is 21 AA 684 and 21 AA 869. It's the Consolidated Appeal Office of the People's Counsel for the District of Columbia versus the DC Public Service Commission. And I will say before counsel begins arguing, there is a sea of acronyms in this case. If you could appreciate the fact that others are not quite as conversant in this language. I am bound to mix up OPC and PSC at some point in the argument. If you don't understand who I'm talking about, please just ask for clarification, but I just
Certainly.
anticipate that mix up.
And certainly, Your Honor, if you don't understand what I'm talking about, please ask me and I will.
We definitely will. That's why we're here. So with that preface, if you could try and speak in layman's terms, it would be much appreciated both to the bench and I'm sure to the public that's watching.
I will do my
So
best.
counsel, when you're ready, if you would introduce yourself and let us know how much time you'd like for
Very well.
rebuttal.
Scott Strauss for the Office of the People's Counsel. I'd like to reserve 4 minutes for rebuttal. The office is challenging the commission's decisions with respect to Benning Station investigation costs and energy efficiency program costs. I'm going to begin with the Benning issue.
Counsel, your voice is a little bit faint. I don't know if you need to raise the podium a little bit or get a little bit closer to the mic. But I'm having a little bit of trouble hearing you.
Trying to raise the podium, but I'm not able to do it, Your Honor.
There should be a button on the
Yeah,
side.
And there is, and I'm pressing up
It's not, okay,
and it's not moving.
all right,
So
hold on.
I
We've
will
gotta-
bend down.
No, we want you to be comfortable at the podium.
It's not working.
Okay, all right.
Fair enough.
I apologize about that if there's a. you
I will
can
speak
adjust the
loud.
mic. Great, thank you.
More than 2 decades ago, PEPCO committed in a commission-approved settlement agreement that it would not charge its distribution customers for Benning generating station costs. OPC is here today because the commission failed to hold PEPCO to that commitment. The commission's ruling that the settlement permits PEPCO to bill distribution customers for environmental investigation costs is wrong for several reasons. First, it misreads the settlement. The settlement's prohibition on the inclusion in rates of Benning station costs is unqualified. It is not limited to operating costs. It doesn't say the plant even has to be running for the protection to apply. It's broad and it should be read broadly. Second, there is evidence in the record that the investigation costs are Benning generation costs. the district's 2010 intent to sue letter, which led to a consent decree initiating the Benning investigation, references a release of PCB contaminated caulk located inside the generating station's cooling towers. And the EPA report accompanying the district letter, and that's in the joint appendix at page 52. And the EPA report accompanying the district letter refers to a sludge dewatering area that is used in connection with the cooling towers as the quote, only potential uncontained potential source identified on the site. That's a close quote, and that's in the joint appendix at page 54. Now, third, while the commission permits PEPCO to recover the investigation costs incurred prior to 2018, it rejects recovery of the same investigation costs incurred thereafter.
Is it right to say rejects or just at least postpone?
It postpones. Postpones would be better. It defers. The commission did that because it found it lacked sufficient information to decide how to allocate those costs among the generation, transmission, and distribution functions. The commission
Is that the only reason that it deferred? I mean, I understood what the commission to be doing is to say, well, we think under the 2018 settlement, these costs are completely approved. So that's why we'll go ahead and grant these RI remediation investigation costs, just showing off my acronym skill. So that's why we're going to let you recover those, PEPCO, but we're not going to let you recover future costs or subsequent costs because we don't have an agreement about those and we're not sure what to do with them. So it's premature. Let's kick the can down the road.
Two things about that. First, it's the same cost. It's the same investigation. The only difference is a set of them were incurred prior to 2018.
Well, that is a question that I also had about it being the same investigation, same cost. I mean, are they billing by the hour? I mean, how is it that?
I think it's a lengthy process, Your Honor.
For sure. It seems to be. It's been going on for quite some time.
It has.
And it doesn't seem to be anywhere near completion.
Apparently not.
So, but apparently they've been able to document costs in the amount of $3-point-something million to date. So how does that cut with your argument?
The commission says, gee, there was a prior settlement in which you agreed to pay these costs. That's the settlement in what's known as formal case 1150 and 1151. But what that settlement says, as we point out, is that cost recovery can begin, but the issue of the merits of that recovery will be deferred.
But can we put a pin in that? I just want to circle back to your third argument, right? You said, look, this 1999 settlement is broad. It actually covers all sorts of costs related to the generating plant. And there actually is evidence that these remediation investigation costs are related to environmental damage from the generating facility. And this doesn't make sense because you deferred costs for the same investigation going forward. And I just want to drill down on that it doesn't make sense argument. Arguably, it does make sense in their head if they think the 2018 settlement agreement completely approved costs, which I understand you disagree with, right? You take issue with that.
Right.
But if that is correct, then that is a reason why deferring future costs might make sense.
Even the commission admits in their brief at page 31 that the office plainly had the right to contest the pre-2018.
Okay, so now we're on to the 2018. We're talking about what the 2018 settlement agreement means.
Correct.
Okay, that's fine. But
the reason is, the office's position is that it is arbitrary to treat the pre and post 2018 costs, the investigation costs.
And my only point is it's not arbitrary if in fact they're correct about the 2018 settlement agreement. So it collapses in, but then let's get to what the 2018 settlement agreement actually means. But let's first take
follow up on that.
Police's question.
Yes, sure.
Is your point in part that at one level, it might make sense to say, look, we already approved this type of cost in 2018. I know you don't agree with that. Right. You don't think that was done. What was done was a regulatory asset was created, and then people could fight about whether it would be taken out of costs. But if whatever substantive decision, if that decision was made, then it wouldn't make logical sense. If you've already made that decision that it's going to be recoverable, then the logic of that would be, so too should the similar costs going forward. Is that part of your point? Because it would be an odd substantive discrepancy.
It's an odd discrepancy. What was agreed to in the settlement was that the cost recovery could commence.
No, I understand that.
We're talking past each
I know.
other.
Well, no,
Sorry.
it's just that there are two things going on, and it's hard to juggle both balls. Although it's not that hard to juggle two balls, but anyway, right now it's hard to juggle the two in single questions and the like. I'm just wondering. I know there's a question about whether the commission was correct to think, at least in its original order, it seemed to pretty clearly think this, that these costs had already been approved.
Correct.
I get that, but just on the question of sort of leave aside who did what when, as a matter of substantive what you should approve or what you shouldn't, it would be odd to in fact approve the having already approved. If you did, which I know you don't think you did, but if you've already approved these remediation costs backward looking, then why would you defer them forward looking? Because they're the same substantive kind of costs.
Exactly.
That would be logically inconsistent.
Absolutely.
Even though I understand there's a very different procedural posture.
And that's the problem. It is logically inconsistent. When in the settlement context, the commission said, this settlement is in the public interest, we approve it. When it came to the rate making context in the next rate case, the commission looked at all the evidence and said, gee, we don't know. This might be a generation, it might be a transmission, or it might be a distribution cost, and we're not prepared to say today.
And I don't know that you make the argument quite this way, but I guess one could think, tell me what your reaction to this is, that to the extent there's any uncertainty about what the commission did in the, I'm not sure I'm gonna get the year right, 2018 order.
The which one?
What the commission did in the 2018 order.
The settlement order.
Yeah, the settlement order. Oh, there's also a settlement agreement, so it gets confusing. If you're trying to figure out what that meant, how to interpret it, if you were unsure, the fact that the commission, with respect to forward-looking, says, really, we shouldn't be approving this right now. We'd have to think of a lot of, we'd have to sort out a lot of issues that haven't been sorted out yet. That would tend to suggest that it may be less likely that the commission's earlier order reflected an approval of those costs definitively.
And that's the point that we're trying to make. They're not sure. They need more evidence, and they specifically say in paragraph 274 of their order, 20755, and this is at the joint appendix of 2788. They say a review of the request raises concerns about the past uses of the site and how costs for the RIFS, which is the remedial investigation feasibility study, and actual remediation should be allocated among generation, transmission, and distribution, and ultimately the amount that should be recovered from district distribution customers. They don't know. They're not sure, and that's fine. In our view,
there seem to me like there are two overlapping but distinct issues. I don't see if you think I'm oriented correctly on this or not. There's a question of what the settlement agreement language meant when it refers to, costs. This is a paraphrase, costs relating to the, Bennering Road generating station.
Right.
And there's a question, if there hadn't been that kind of an agreement, there would be a question about what's fair in terms of putting on the back of current customers the cleanup costs that may have been relate to activities that aren't all necessarily backwards looking or forward looking, that tied to the interests and benefit of the customers. Those are overlapping but distinct. Is that accurate?
I'm sorry,
those are overlapping but distinct. Is that
those
accurate?
are overlapping? The costs are overlapping. The consideration on the one hand was the role of the settlement, and on the other hand, you didn't have the settlement. The other thing I want to point out, though, they're not sure what box to put these costs in. That relates back to the 1999 settlement as well, which said no Benning station in the cost of service. If they conclude that these were generation costs, then the settlement prohibition applies. It's too soon to tell, apparently. The commission wants to consider that. But here instead they said, oh, the settlement.
So let me ask my question a slightly different way. Do you, if the task for the commission in general to figure out what portion of these costs would be fair to allocate to current customers, do you think that's exactly the same question as trying to figure out whether, for purposes of interpreting the settlement agreement, these are Benning Road generating station costs? Are those exactly the same?
It amounts to the same thing as follows. Remember, with the 1999 settlement, we moved into a different world. a restructured world in which generation, transmission, and distribution are separate functions. We're talking here only about what the distribution customers pay for the delivery of electricity. Think about your electric bill. You pay a separate charge for generation. You pay a separate charge to Pepco to deliver that energy to your house. And separately, there's a transmission charge that you pay that's regulated federally. And so the question here the commission was grappling with was, we have a restructured arrangement. What would be fair to put in the distribution box? That's the same question, whether it was pre-2018 or post-2018. That's the point that I'm making. The commission also says that the costs they were looking at in the post-2018 period, unlike the pre-2018 period, were remediation costs and not investigation costs. That's not the case. It's clear from the record that they were both remediation and investigation costs. That is in the joint appendix at page 23. Pepco witness Sanford says that. And it's also noted in the order, again, at paragraph 274. The commission's other justifications don't hold up either. Commission says that the customer should pay the earlier investigation costs because the site is devoted entirely to Pepco's service center operations. Pepco testified that the site was being used for both the transmission and the distribution functions. And at the time the consent decree was entered, Benning was running. So it was also being used for the generation function.
So that is a question, right, that I have about the 1999 settlement agreement, right? I take your point. The language that the Public Service Commission seemed to find in the settlement agreement isn't written down, right? To the extent the Public Service Commission said that the settlement agreement only applied to future operating costs, the word future and the word operating aren't in there, right? So
Correct.
It says, in connection with any Pepco base rate proceeding in DC instituted after June 30th, 2000, the Benning Road and Buzzard Point generating stations shall not be included in the cost of service. So it's the stations as a whole, and you're arguing they don't even have to be running, right?
Correct.
And yet we also have information that the stations are the Benning Road station in particular is situated on the 77-acre facility.
Correct.
So assuming we agree with you that whatever cost is recovery of cost that's prohibited under the 1999 settlement agreement is broad, right? It's any cost related to the generating station. Do we then run into some ambiguity there about, like, well, what is a cost of the generating station? Do we have to, do we need to have someone tell us, well, the generating station, at least in 1999, was operational on, X number of acres of this facility supported the generating station? Do we need facts like that?
You're going to have someone tell you, and that is the commission. The commission has said, when we get all the information about what this costs and what Pepco plans to do with it, then we will look at the question of which of the various boxes to put these costs into, whether we treat them as generation costs, transmission costs, or distribution costs.
I think you're answering a slightly different question. I'm just wondering, as a factual matter, do we need, and I don't know that it's in the record right now, do we need someone to tell us historically, well, in 1999, the property that would have been considered supporting the generating stations was 100% of the 77
that
acres, or
is,
50% of
that information is in the record. The information about the size of the plot that the plant occupied versus the site as a whole. Give me a moment.
Well, I understand. I mean, sure, there's a map, right? And you've provided it to us and we can sort of see where things are, but that arguably only tells you so much. I mean, you're not saying that it's only the remediation costs of the ground that the building that was the generating station sits on is what is prohibited, right?
We don't know because the investigation isn't done as to what.
I think I'm just not being clear.
Yeah,
I'm not
maybe
asking
maybe I'm
about,
just not,
I'm
I
not asking
apologize.
about the investigation and what the investigation does or doesn't show.
Okay,
I'm saying that the settlement agreement says you can't recover costs from the Benning Road generating station. And I'm saying it seems like there's potential ambiguity, but you tell me if you think that there is not, about what it means to prohibit recovery of cost from the generating station. It seems like, to put a finer point on it, Pepco might have an interest in saying, well, if that does prohibit not just future operating costs, but costs broadly, it's only the cost for the actual footage of the building and nothing more.
they may.
And I would imagine that you would say, that's crazy. It's on a much bigger parcel and people had to come in and out of the facility and store stuff and do stuff. And so,
and there would be, you're right.
so it seems like there's a factual question that needs to be resolved of how much of this 77-acre parcel
properly
can be
falls under this
considered
restriction.
the generating station, or as the language elsewhere in the 1999 settlement refers to, the generating plant.
That will be an issue
Okay,
when all the information is in. And the commission is able to make a determination about the buckets to put these charges into. There will be, there unquestionably will be another hearing and an opportunity to put in evidence on that issue. The point for
And
this is,
I think I've asked this question before.
Sure.
And I think I understand your answer, but just to try to zero in on it again. With respect to the that inquiry about what in the language about the generating plant or the generating station means in that
Correct.
agreement.
Yeah.
Is, you think, basically similar to, but I'm not quite sure whether you think it's identical to sort of the inquiry that Pepco, I mean, that the commission would undertake in a general rate making proceeding without regard to the agreement about what would be fair to impose. It seems to me like it could be different. It might not be the same as what they would, if there hadn't been that agreement, what they might think, oh, here's kind of what fairness would say about what portion of these costs should be borne by current ratepayers.
well, I think they will determine what buckets to put the various costs in, and that will bear on how the settlement applies and to what it applies. Here they said, look, the settlement doesn't mean what you said it meant, forget it. Our point is, you don't have the evidence to do that. You yourself aren't sure. When you're sure, come back and let's debate this then. So if as we said, it's premature. And the best evidence of the prematurity is what they themselves did. Their only way out is to say the earlier settlement required you to pay this. It certainly required cost recovery to begin, but it left open the opportunity to challenge those costs on the merits in the next case. And that's what happened.
well, it seems like they've conceded that at this point.
And I
The
believe that
Public Service Commission has conceded in its brief.
they say that it's plain we could bring the challenge, but there was no obligation on their part to accept it, and we don't challenge that.
Right. That's not your argument.
My time is up.
Do you want to quickly address your statutory argument?
The second issue. Give me a moment. Try to do that briefly. The commission's decision to allow Pepco to place $5 million in energy efficiency program costs into a regulatory asset is also an error. The Clean Energy Act of 2018 says that Pepco can't apply to put program costs in rates without first consulting and coordinating with the sustainable energy utility. And then it must demonstrate to the commission that the program it's proposing is not substantially similar to programs that the SEU either has or is in development. Pepco didn't conduct the consultation or coordination. Commission says the obligation is not mandatory, but that reading can't be squared with the text. You have to consult and coordinate, and then you apply. You don't get to skip the step. Now, the commission says that short-term efficiency programs are outside the scope of this obligation, but the obligation isn't read as limited in that way. And The commission says that the office failed to show that PEPCO's proposed programs were substantially similar. It's actually not our burden to do that. It's PEPCO's burden. But even if it was, we put evidence into the record on that subject. We had an expert testimony, and that can be found in the joint appendix at pages 1732 to 33. Now, in briefing to this court, the commission and PEPCO counsel argue, I believe for the first time, that even if there was a consultation requirement, the commission could look past it and disregard it because this was an alternative form of regulation proceeding.
Did the commission, you may be right. Right now, I remember PEPCO making that, or I wasn't so
I
sure. that
believe the commission made a similar argument. I know that PEPCO, you're correct. PEPCO definitely made that argument. I believe the commission made the same argument. When I come on rebuttal, I'll let you know. The point is, the commission shouldn't, I'm sorry, the court shouldn't be considering arguments that the commission didn't put in their orders. That's not the way this works. Council doesn't get to make up rationalizations on appeal.
In the same general vein, if I'm recalling correctly, one of your opponents suggests that some of the points you're making on this general topic of the energy efficiency were themselves belated in front of the commission because they really weren't developed until reconsideration.
They were raised on reconsideration. The commission considered them. No one has claimed they were waived. And remember, these are statutory arguments. I didn't need a witness to testify to them. What I needed the witness to testify to was that there was some potential for overlap. And we did have that factual testimony in the record.
Does it matter to the second order? You say you requested reconsideration. The commission's order is, I think, referred to as a clarifying order.
It's an order on reconsideration.
Okay, I thought they used the word clarifying instead of, and so I wondered if that mattered, but hasn't that order been separately appealed? I mean,
Yes.
Yes.
Yeah, it's been appealed. It's actually called, I take it back. It's for applications on reconsideration and clarification.
Okay.
And in the case of this issue, it was a request for reconsideration, raising the additional points. The point I want to make about that argument, if you intend to consider it, what the statute on the alternative form of regulation says, and this is DC Code 34-1504 D1, is that the commission has the authority to override contrary code provisions to adopt an alternative form of regulation. Well, fair enough, but the Clean Energy Act provision that we're talking about doesn't prohibit the adoption of alternative forms of regulation. It simply says if PEPCO wants to put these kinds of programs in their costs and rates, then it needs to go through a process to do that, and it hasn't followed that. They can be harmonized, and there's no reason to find that one overrides the other. And finally, the commission is required to make findings that the programs that PEPCO is proposing are in the public interest and consistent with the commission's with the council's climate commitments. And I don't see how you make those findings if you don't know whether or not the programs are duplicative of programs that the sustainable energy utility is itself developing or has developed. To be clear, the commission also talks about, or PEPCO may talk about the emergency nature of these programs. It's not clear, there's no finding on the record that because of the emergency, PEPCO didn't get to talk to the sustainable energy utility. That's not a finding. There's no emergency exception. And be clear where the office is. We're certainly not against energy efficiency programs. We're not against helping customers in a pandemic. We just want to make sure we're not paying more for that than is necessary, which is especially important during an emergency time. Thank you, Your Honor.
Thank you, counsel. I realized that I neglected to ask the Public Service Commission and PEPCO how they intended to split their time. Could you let me know? Why don't you take the podium and you can, I don't know if you intend to keep your mask on, but I can hear you better at the mic. Can you repeat what you just said?
I'm sorry, what I said was that we would be yielding 5 minutes of our time to PEPCO today.
Thank you very much.
Good morning, Your Honors. My name is Kimberly Lincoln Stewart, and with me is Rick Herskovitz, and we represent the Public Service Commission of the District of Columbia. This matter is before the court with two main issues. The first issue being whether the commission erred in approving recovery of study costs for the Benning Road facility. And the commission believes that its interpretation of the settlement agreements were reasonable. There are two settlement agreements at issue. There's the FC 1150 settlement agreement, which that agreement gives OPC and the parties agreed that study costs, which are the RIFS, and I'm just going to say study costs are recoverable with respect to the Benning Road facility.
Could we refer, just so that we are all speaking the same language, could we talk about the 2018 settlement agreement, which is, I think, what you're just referring to now? And
Yes.
and the 1999 settlement agreement? Would that be perhaps imprecise, but help orient me?
I will try to refer to them as the 1999 and the 2018, or the first settlement is the 1999 and the second settlement is the 2018.
Right.
I will try to
I
keep
appreciate
with
it.
one of those two.
And on the subject of the 2018 settlement, I see that at an earlier point in time, the Public Service Commission seemed to say, look, the 2018 settlement essentially approves payment of $3.3 million, but I understood the Public Service Commission to take a slightly different position on appeal and say, and I'm quoting from your brief on page 31, that you don't contest that OPC has the right to challenge PEPCO's entitlement to further recovery of the 3.3 million regulatory asset, right? And that you concede that the 2018 settlement agreement plainly reserves OPC's right to challenge PEPCO's entitlement to further recovery. So if that's the case, do we really need to talk about the 2018 settlement agreement, or can we just talk about what the 1999 settlement agreement means and whether it gives a valid basis to challenge recovery of the 3.3 million that was put into this regulatory asset?
Your Honor, the commission does recognize that there is an ability to challenge the 2018 the regulatory asset. It's not, but it's different. It's not the creation of the regulatory asset and the money that's in there, because there are two periods. There's the period before 2018, which 2018 addresses as the pre-period. Those are already actual costs that could go into rate base.
Well, it could, right? And that's the point, right? Maybe I don't understand what a regulatory asset is, but my understanding is it's sort of it's a recognition that you are telling us these costs have been incurred. We are going to create this accounting mechanism to say, we're going to set aside this money, but you still need to come back and apply to us for it. And we need to approve it. It's not,
That's correct,
there's
Your
an
Honor. It's
interim step, right? Where we're not just handing you the check by virtue of agreeing to create the regulatory asset. There's the approval. And I thought what the Public Service Commission was saying is, okay, we get it. We were sort of reading the 2018 settlement agreement as effectively the $3.3 million is yours, PEPCO. We're taking a step back and agreeing, OPC, you have an ability to challenge the disbursement from this regulatory asset. Am I mistaken about what your position is?
Well, the position for the commission is that it is a regulatory asset, and a regulatory asset is a tracking mechanism. And it gives the utility and everyone an opportunity to be able to look and see what expenses or costs there were associated with a given item. And in this instance, we're talking about the Benning facility. But that regulatory asset will be addressed in a future rate case, and that's
I thought
basically what
that's
it
where we
says.
are now.
So there'll be a prudency, well, in this instance, we looked at.
Aren't we in a future rate case now?
We are, and
Okay.
so when we're talking about the rate making adjustment number 5, which is the regulatory asset treatment, that's an actual cost. And the commission looked at all of the facts and factors with respect to those costs.
I think we're talking past each other. No one's questioning that Pepco has incurred north of $3 million in costs. The only question is who has to pay for it, right? And so I understand a regulatory asset was created, but I thought that at one point OPC was, or sorry, I knew I was going to do it, that the Public Service Commission had said, look, this is already approved. There's nothing to do here. And now you are agreeing that OPC has the ability, that the door is open for OPC to come to the commission and say, you can't give them this money. And here's why. You can't give it to them because of the 1999 settlement agreement. Now we can have a conversation about what the 1999 settlement agreement means, but I'm just trying to get the commission's position on whether the door is open or closed for OPC to make the argument.
OPC in this instance made the argument in the commission.
I'm not asking historically, I'm asking legally. Under the 2018 settlement agreement, is the commission's position that the door is open or closed to OPC?
OPC was able to challenge.
That's not the question. That's not the question. The question is, what does the 2018 settlement agreement mean? And does the commission interpret the 2018 settlement agreement, in particular, the language, notwithstanding the foregoing provision, the parties agree, blah, 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 blah. Do you think that that language opens the door to the challenge that OPC made in this case? Or should they have not been able to make that challenge because that language didn't allow for a challenge? Are you understanding my question?
I believe I understand what you're asking. And the commission allowed OPC to challenge in this case.
But in the record below, it seemed like they said, I mean, sure, we're allowing you to make the challenge. We hear you. We are entertaining the challenge. The 2018 settlement agreement doesn't allow you to do this. We're done here. Am I mistaken about that?
I think what the commission did was the commission looked at OPC's challenge and was more persuaded by the reading and interpreting the 2018 settlement and the 1999
trying to
settlement.
take them one by one, and I'm just not getting an answer from you. But I guess I'll take that as an agreement that the door is open to a challenge. And so the only question really is, what does the 1999 settlement mean? Is that fair?
That's fair, Your Honor.
Great. Okay, so now we're on to the 1999 settlement agreement. And why don't you tell me what you think? Why does the commission think that it only applies to future operating costs when the future and operating don't appear in the language of the text of the settlement agreement?
Well, Your Honor, I believe in looking at the text of the agreement and we have to all put it in context. At the time of the—
Well, do we? I think we have to look at the plain language of the agreement first.
Well, yes, Your Honor, in looking at the plain language of the agreement, it was a divestiture rate case, and what was happening in this agreement at paragraph 1.05 specifically was talking about the generation assets that were being divested or were being required to be divested by the company.
Right, and I read the full agreement and they said, okay, you can divest all of these other assets. There are two that we have concerns about.
Well, when you say,
Undefined concerns, but
when-
concerns are in, it says concerns in the agreement.
okay, when you say
Right.
too concerned about, those two, Buzzard Point and Benning Road, and if you read the entire settlement agreement, those two were being retained by either Pepco or whoever they may sell it to,
Well,
but it was for
pause.
purposes of reliability.
Pause. I'm not sure that purposes of reliability appears in the agreement, but that they identify these two locations as subject of concern. And then they specifically set out terms and they say, if you don't sell these, here's the deal. Going forward, you cannot recover stranded costs, which what I understand to mean is if you sell later on at a loss, you own that. You cannot pass that on to the consumer, right? And if you keep it, those costs can't be passed on to the consumer either. It's the flip side of the coin. You retain these locations, your choice. We're not forcing you to sell them. But if you sell them later, you can't pass the cost on to the consumer. And if you keep them, you can't pass the cost on to the consumer, right? They are yours and you own those costs, Pepco, and you pay for them. You don't pass them on. That's how I read the settlement agreement.
Well, you're talking specifically about the Benning Road operating cost. And-
I'm looking
and
at the
nothing-
provision-
And nothing more.
That I am looking at the settlement agreement and the specific paragraph that deals with those two stations. And it gives two options that I just described.
Yes, and the commission reviewed the settlement agreement, and with its expertise in knowing what cost of services are. In this particular instance, the cost of service is the cost incurred by the utility in producing and or delivering the services requested by customers.
Are
The
you
vending
saying,
facility wasn't
the
providing
cost of
any-
service, excuse me, are you saying that cost of services equals operating costs generally? They're the same thing
In this
general?
settlement agreement, it specifically is talking about the cost for operating the binning, the
Where's the
generation.
word operating in the agreement?
I'm sorry,
Where's the word operating in the agreement?
it's not in the agreement, but the commission with its
Well,
expertise.
but just more
in
generally, so
rate
leave aside the
making
agreement,
knows-
leave aside the agreement for a minute. Would you agree that operating costs and cost of service are not synonymous terms? They're different terms.
One is subsumed in the other, I would argue.
Right, so they're not synonyms. They're
Correct.
right, they're related but distinct, not
Which
synonymous.
is subsumed into which one?
Operating costs would be.
I think that
subsumed.
would, appropriate operating costs could be treated as a cost of service, I would
Correct.
think.
And those
So they're not
not
generally
necessarily
synonymous. So the point
appropriate, but
is-
those that are approved by the commission.
Understood.
Because
That's what I-
Pepco or any
right.
utility could put forward a variety of costs.
Understood.
And the commission, on a case-by-case basis, will make a determination of what are appropriate operating costs are going to cost. of
Understood.
service.
That's why I used the word appropriate. But my question is the following. I gather from what you just said that cost of service doesn't generally mean the same thing as operating costs, or much less future operating costs. So they're not generally synonymous. But you are arguing that the commission correctly concluded here that in the context of this particular agreement, the more general term costs of service should be construed to be limited to and synonymous with future operating costs. And I'm just trying to figure out why. It's not in the text, obviously. So your argument is something about context. And why do you think it would be so limited? What's the reasoning why that's a contextual but unstated limitation of the generally broader phrase of cost of service?
Well, the commission has been given plenary authority over rate making in the district. And through that authority, the commission has gained an expertise or has the expertise to make determinations on what elements or what things go into rate making and cost of service, or what is a stranded cost. And in this instance, stranded cost is really not at issue because OPC has conceded that they weren't arguing stranded costs. So in this instance, with respect to the cost of service, we're talking about the continued operation of the Benning Road generation station.
I grant that the commission has expertise in this area. This is a settlement agreement with a number of parties. It's a contract, right? Where everybody has to have a meeting of the minds on terms. And I'm struggling to understand how the commission's expertise maps onto that. You'd think that everyone needs to be on the same page about what cost of service means. So I'm trying to understand why the commission's expertise has anything to do with interpreting the plain language of a settlement agreement.
Well, under the national fuel gas supply case, courts should give deference to an agency's reading of a settlement agreement, even when the issue simply involves the proper construction.
Right, I saw that you studied,
Excuse me.
I saw that you cited that case. It's from the DC Circuit. You seemed to think that it was very important for us to know about that. Do you think that case is binding on this court?
Your Honor, the case is not necessarily binding on this court. However, the court does view the cases in the DC Circuit as
Informative?
Guiding.
Informative?
Informative.
Sure. We view cases from other circuits as informative as well. That case, I believe, is from 1987. Is that?
I believe so.
And it grounds its rationale in Chevron, which has had sort of an interesting life and is perhaps not as respected as it used to be. What do you think we should make of the DC Circuit's reliance on Chevron in light of the current law, agency law coming out of the Supreme Court of the United States, which we do find extremely informative, if not binding on us?
Well, with respect to reliance on the natural gas case and Chevron, DC has a case of its own, which the commission relies on, which is the Washington Gas Light versus PSC 450 Atlantic 2nd, 1187 at 1193. And it also says that the court should accord great deference to the decisions of the commission because of the expertise that we have in rate making.
Is that with respect to interpreting settlement agreements, though?
Well,
right. I thought that's why you really wanted us to look to National Fuel, because that's talking about a settlement agreement. And I think it's kind of interesting that Judge Bork thought that we should be deferring to the commission in interpreting settlement agreements, which are in the nature of contracts, not interpreting statutes, organizing statutes or regulations, right? That's what I usually think of as deferring to agencies' expertise, right? Not in interpreting contracts with outside entities, binding agreements that you need a meeting of the minds.
Well,
on.
Your Honor, that may well be one way to look at it. But the first thing the court should recognize is the 1999 settlement agreement, OPC was not a party to. So OPC
didn't exist, right? Did they exist, or were they nascent? I don't know.
I don't know if they existed, or I believe they existed. I believe they existed, but I can't tell you right off the top of my head when OPC was created. But what I do know is if you go back and look at
PEPCO was a party to that settlement agreement, right?
Yes.
And they promised they said to the commission, we would like to divest. We would no longer want to have our generating facilities. We want to be just a distribution only operation. And they had to get the commission to sign off on it. And the commission said, okay, but with this caveat, as to these facilities that we have concerns about, here are the terms. and Pepco agreed to those terms. Are you saying that OPC does not have standing in its statutory authority to raise the settlement agreement and say that Pepco is violating a settlement agreement that it signed? Or are you
No, Your
saying that because it was 20 years ago, we don't have to pay attention to it anymore?
No, Your Honor, I'm not saying that Pepco doesn't have standing, but with respect to interpretation of the settlement agreement, their interpretation would certainly not be any better than the commission's.
We're not talking
interpretation.
about their interpretation. I'm asking about the commission's interpretation, and the commission seems to have read language into the settlement agreement. Right? It says
Your Honor,
the
I
settlement
think-
agreement only applies to future operating costs, future and operating not being in the language of the settlement agreement.
Future operating costs may not be in the language of the settlement agreement, but the commission's expertise.
Can I ask you about that? Because let's assume for a moment that we would defer to the commission on this. I haven't yet heard, you've said in general, well, the commission concluded that, and the commissioner are the experts, so who are you to think otherwise, is about as far as we've gotten thus far. And obviously we have an obligation to review, even in areas where we owe deference to agency expertise. So could you be more specific about, and could you point me to places where the commission's order, more to the point, was more specific about, here's why, although these terms aren't generally the same, here's why we're going to read this settlement agreement to be limited to future operating costs, because A, B, and C, specific points that tap into the commission's expertise that we could assess and determine whether they were reasonable or not. So what's the more specific story about why, the expertise of the commission leads reasonably to that facially counterintuitive conclusion about the scope of this provision?
Your Honor, and I don't know the page in the record, but I want to say it's paragraph 101. But the commission, what the commission did in the order was we referred to a formal case 945 settlement and settlement agreement, and we went through the settlement agreement and looked at, and I believe it's in the order 21042, which is in the record at JA 3067 through 3149. And it actually, paragraph, I believe it's 101, where we discuss the Benning Road, the settlement agreement, and we say what we actually said, the pertinent language for the settlement agreement, and then we say that the language doesn't eliminate the company's ability to recover from customers the reasonable and prudently incurred costs. So the commission reviewed, and in that paragraph,
seems even more counterintuitive. I mean, and different from, it's limited, it does preclude future operating costs, even if they otherwise would have perhaps met general rate making requirements of, reasonableness and prudence and the like. But that language by itself seemed to say it has no effect. All that it does is sort of duplicate the general requirement that Pepco is not going to be able to be authorized to recover prudent and appropriate costs. That would seem to read that part of the settlement agreement completely out of, it would be redundant, because that's a general rate making requirement anyway.
I'm not understanding is that a question? And maybe that's better. Could you rephrase the question?
Sure. You quoted some language that seemed to suggest that the commission was interpreting the last sentence at issue in the 1999 agreement as permitting recovery of any costs relating to the Benning Road generating station or plant, as long as they were prudent and reasonable. And my question is, if that's the position of the commission, I guess it's got two halves. A, that seems different from what they said in what was said in the order about future operating costs. And B, it seems like that would make that latter sentence a nullity or superfluous, because PEPCO generally, regulated utilities generally can't, even in the absence of a settlement agreement, recover costs that aren't reasonable and prudent.
Your Honor, I think there are two different points. There are the costs that are the pre-2018 costs, and then there are the future costs after that 2018 agreement. And I believe the language is speaking to the pre-2018 costs, which would be recoverable based on the commission's interpretation of the agreement.
And I guess the question is why? The language doesn't seem to suggest that. And so if the commission is saying, well, maybe that's not written in those terms, but here is our conclusion and here are our reasons for our conclusion, I'm still, I guess, unsure about what the specific rationale tied to the agency's expertise or the commission's expertise that would support that interpretation.
Well, again, Your Honor, I think it's tied to what was going on with the settlement agreement. During that time, PEPCO was divesting itself of generation assets, and the Benning Road station or facility was one which was maintained because the district needed to ensure that there was reliability. So the settlement agreement is speaking to prohibiting PEPCO from being able to get any of the stranded costs. And it was specifically, and I want to say that they needed the Benning Road facility to continue running for reliability. And so the continued operation of the Benning Road generating station they were trying to make sure that those costs, the operation, not the study costs, those are different. The operational costs were not included in the cost of service.
So
in the
the
future.
problem is that the plain language of the agreement that a number of people signed on to doesn't say that, right? And so you're saying, well, defer to the commission's expertise in interpreting this language. And I think sort of a fundamental question or problem I have with that argument is that, first of all, in the commission's initial order, the commission doesn't even talk about the 1999 settlement. It's not in the initial order. And it's only in the clarifying order that the commission mentions the 1999 settlement agreement, and the commission doesn't purport to be interpreting this language and say, you know, here, we think this language might be ambiguous, but here's why we're interpreting it this way. It purports to be doing a plain language reading and says, on its face, that's a quote, the language in the 1999 settlement agreement did not bar recovery of PEPCO's costs for future environmental remediation, only stranded costs and future operating costs. And I wonder, can you agree? The language, maybe you think it can be interpreted to only apply to future operating costs, but do you agree that on its face, it does not say that?
Yes, Your Honor, on its face, it does not say that, but it
Okay.
can be interpreted that way
Perhaps.
based on the expertise in the
Okay.
esoteric area of
But
the law, the
if-
commission.
Right, generally, we defer to the commission, right?
Yes, Your Honor.
And that's a double-edged sword. It means that when the commission does some interpretive work, takes discretionary action, explains that to us, and then we use our deferential standard of review and think that that action is not arbitrary or capricious or outside of the bounds of law, we'll affirm. But where the commission says it's doing one thing, plain language review, and then is here before us saying, well, please interpret this this way because this is how the commission did or would reasonably interpret this language, but that's not what the commission's order says. It seems to me that we have to remand under that situation. Is there a reason why I'm mistaken about that?
I'm sorry, you said, it seems to me we would have to.
If the commission is saying in its order, the only order that mentions the 1999 settlement agreement, that the 1999 settlement agreement on its face applies only to future operating costs, which you agree it doesn't on its face, then it seems to me that we need to send this back to the commission so that it can do the interpretive work that perhaps it needs to do, and justify why it thinks costs of service should be interpreted as future operating costs. That work has not been done to date, correct?
Your Honor. The commission reviewed all of the information that was available in the record and articulated in the order
It said what it said.
that it says what it says, that
It
it was
says what
reviewing
it says.
operating costs. And
Would you like-
so yes, we probably,
I'm not trying to extract a concession from you that you don't want to make, but I think it says what it says.
yes, it does say what it says.
Would you like to address the statutory argument?
And we're going to the second argument, Your Honor. The energy efficiency.
Or would you like Pepco to address that? We've kept you up here for quite some time and I do want to be mindful of the clock, so.
The energy efficiency programs, Your Honor?
Correct.
I think that just a couple of very quick points and then I'll yield to Pepco and thank you. Just the basic points the commission wants to make is that you know, we said previously that, you know, OPC can challenge these costs in the next rate case for these energy efficiency programs. They're not in rates at the present. Secondarily, there's another proceeding, FC 1160, which we cite to where we're developing these exact energy efficient, not these exact programs, but energy efficiency programs. And that's where the DCSEU and others would get a preliminary look at the programs and can make or say this is duplicative or not.
But if the
more-
statute says you need pre-approval beforehand, right? If the statute says that a condition precedent of applying to the commission to offer these programs and then get paid for offering these programs is consulting and coordinating with the DOEE, the Department of Energy and Environment, and the district SEU and its advisory board, then do you agree that that didn't happen? And so we.
Your Honor, I can agree that it didn't happen because the Clean Energy Act is inapplicable to these programs for several reasons. The first reason is the Clean Energy Act requires that they be long-term programs and they're.
Where do you find that language? Because the Clean Energy Act seems to refer to an interest in programs that are provided on an annual basis as well as a long-term basis. I don't see any limitation on long-term programs.
Your Honor, I believe 1.774.07 G5 says long-term, and it may say long-term and annual,
Right.
but
It refers to all energy efficient and demand reduction programs in the district.
but no, it's for also low-income residential. So you're talking about residential programs.
It doesn't limit it to that.
Just a moment, Your Honor. Your Honor, it says, and when you say it doesn't limit it, it starts off with,
Can you orient me where you are in the statute?
I'm sorry, I'm at the section 5, G5. An application submitted by the electric company or gas company pursuant to this subsection shall meet the long-term and annual energy savings metrics, which shall primarily benefit low and moderate income residential ratepayers.
Can I ask
to
you
the
about,
extent possible.
it seems as though you were suggesting, and the commission was suggesting, that the application has to be like long-term or annual, and that the application has to primarily benefit, but that's not the way it's worded. The way it's worded is the application has to meet certain metrics. The metrics are created by the commission pursuant to this general program. So there's annual and long-term metrics that have a particular purpose that are being created by the commission independently of any application by a utility. Is that, you agree with that?
Say, repeat that, Your Honor.
So the way I understood it is that on other provisions of the statute, give the commission a set of responsibilities independent of an application by a particular utility. And that the commission, in doing its work under the statute generally, have to create annual, long-term and annual saving metrics. And those metrics have to have a characteristic, which is that they primarily benefit low and moderate income residential ratepayers.
That's correct.
And now if I'm a utility and I come in and I say, I have a program that, an energy efficiency program that I would like to, be able to get funded through the rate making process, my application has to meet whatever metrics the commission has created. But my application doesn't itself have to primarily benefit. It has to meet the metrics that the commission created that have to primarily benefit. And my application doesn't have to be long-term or annual or anything else. It has to meet some metrics that are long-term and annual and the like. Or am I misread? So I just read the provision a little bit differently. So I feel like I might be missing something.
Well, the commission's interpretation of this provision, which is the provision that it is required to administer, specifically looks at, in this instance, we looked at the nature of the programs being offered, and the basis for that. Because if you look in the record, the commission clearly required PEPCO to, after COVID pandemic emergency hit the District of Columbia, we required the utility to come back into the rate case and give us some additional testimony, additional evidence of how the pandemic would affect and what they could do about any effects of the pandemic on ratepayers. So PEPCO came back and brought an energy efficiency program. But the programs that they brought back some for residential and they brought back some for small commercial. The ones that OPC is challenging are just the ones for small commercial. And the ones for small commercial, the programs are really
But what does that have to do with the interpretation here? Well, what does that have to do with the interpretation of this specific section? Looking at it, Judge McLeese already read you that first part and the second part. I don't see where it has any limitation on to be a long-term or annual thing. And then it says, which shall primarily benefit low and moderate income residential payers to the extent possible. How does that limit it to just those and exempt those other programs, the commercial ones, from consideration under that standard?
Well, Your Honor, in terms of how the commission has established a case, formal case 1160, that does all of the general, for section 4 and section 5. That particular case provides the utilities as well as other stakeholders an opportunity to address all of the concerns and create the metrics which would be required for reviewing the annual or long-term energy savings.
Counsel,
This specific program.
I read section 4 as saying who needs to apply when. And section 5 is saying, and this is how we are going to evaluate your application, right? And applications that meet the metrics and quantitative performance indicators and cost-effective standards, right? Those are the ones that we'll look on favorably, right? But that's considering the application after it's been made. Section 4 is when the application has to be made, and it has to be made only after consultation and coordination with the Department of Energy and Environment and the District SEU and Advisory Board, right? Because the energy company may apply after doing that to the commission to offer without qualification energy efficient and demand reduction programs in the district, right? That the company can demonstrate are not substantially similar to programs offered in or in development by the SEU, right? So that's when you have to apply for any of those programs, and you have to go to the DOEE and the SEU first. After you've done that and made your application, we'll look at your application under Section 5.
Your Honor,
It's an application that has been submitted. That's Section 5. Will be examined with respect to these metrics
well, Your Honor,
and indicators and standards.
the purpose of the act is, or these sections of the act is to make sure that there's no duplication. And OPC itself conceded that in their testimony and in the record that they didn't know whether or not it duplicated.
Well,
And or it may duplicate. So it was speculative.
Well, how could
Whereas
they if you
Pepco-
haven't done what you're supposed to do under the statute?
I'm sorry.
If Pepco hasn't done what they should do under the statute, how would OPC know? Isn't that the point?
Your Honor,
Isn't SEU supposed to be the expert in this, and they're supposed to know they're supposed to know all the programs, right? They're overseeing all of this.
they're not overseeing all of the programs. They're overseeing those programs which fall within the statute. And the commission
That relate to
does not
energy
believe that
services.
this particular program falls within the statute.
That's what the purpose, you described your view of the purpose of the statute. I'm wondering whether the limitations you're reading in fit very well to that. So one way of looking at this provision is that the district created an SEU, and it wants the SEU, which is kind of a partly privatized way of trying to get energy efficiency. And it wants the SEU to be able to actually be a going concern and function well. And this provision could be viewed as raising a concern, which is, well, if the district goes off, having created an SEU that's supposed to be able to do all of this and make it a going concern, and if it goes off and starts creating other energy efficiency incentives and programs on its own accord, it could undermine the efficacy of the SEU. And so what you want is, before the commission can say to a utility, yes, go ahead and start creating your own incentives and start, improving energy efficiency. Before that can be done, there needs to be consultation with the SEU, and then SEU, either SEU will say, fine, we don't have any problem with that. Or if the SEU says, sorry, that doesn't work for us, then the utility could still go ahead, but it has to show that what it's doing is not substantially duplicative of what the SEU is doing. That general structure and purpose seems like you would want it to apply to all energy efficiency programs that might duplicate what an SEU is doing. And it wouldn't be obvious why you would carve out some of them, like ones that are shorter term in some sense, or ones that are directed at providing their rebates and financial benefits directly to commercial power users. So I'm not quite sure why the commission's, the limitations, the commission, leave aside matters of language, but just as a matter of what makes sense in interpreting the provision, I'm not sure why the limitations that the commission has perceived make sense about how these provisions would logically fit together.
Is that
So
a question, Your Honor?
Yes. Does it make sense to you in any way? And if so, could you shed light?
Well, I think if you look at the totality of the circumstances, what we were facing at the time, when the order was written, we were in the height of the pandemic. There was issues with, ratepayers ability to pay bills. There were issues with, and this is not just residential, but also commercial ratepayers being able to pay bills. So they were trying to find, and the commission asked them in an order. We issued an order requesting that they, and I think that's order number 20349, JA
So,
169 to
we understand that
174.
you've invited it and you brought up the totality of the circumstances several times across different interpretations. What authority allows the commission to ignore the statutes to consider the circumstances of the time and do as it sees fit?
Well, Your Honor, the commission has plenary authority over rate making. And because of our expertise and just having done practice and done this esoteric area of law, we've been given deference by the court because this is an area that we do every day. It's not simple, just as you know, the earlier question about is operating the continued or future operating expense, is that subsumed in or is it different from the cost of service? The commission has to evaluate everything as it comes before us, when it comes before us, as well as what's going on. Like in the first instance, you were talking about divestiture. In this instance, we're talking about the pandemic. And
Does your
because
plenary authority over rate making allow you, is this getting to your argument under 34-1504?
I'm trying to hear the
Yeah.
question.
In the commission's brief, there was an argument that the commission could essentially disregard 8/1774 because it has authority to regulate the regulated services of the electric company through alternative forms of regulation, notwithstanding any other provision of law. Is that the argument that you're making right now?
Yes, Your Honor.
So does that mean, you mean really any other provision of law?
I'm sorry, Your Honor.
Any other provision of law? You can disregard any law,
No, Your Honor.
just this law?
No, Your Honor.
What's the limitation on your argument? Why can you disregard this law but not? I assume you wouldn't say that you can ignore, say, the Human Rights Act.
But Your Honor, the commission doesn't believe it's disregarding the law. The commission doesn't believe.
I thought that was the argument that you were making.
774 applies. The Clean Energy Act doesn't, we don't believe it applies.
I
to
understand you
circumstances.
don't think it applies, but then you just were talking to Judge Howard about your plenary authority. And then I asked you if you were making the argument that you made in your brief under 34-1504. Are you still making that argument? Or are you not making that argument?
Well, Your Honor, the 34-1504 argument goes to the commission's, in part, the determination for the program.
I'm trying to figure out how far you think your plenary authority goes. Right, because your one argument is this statute doesn't apply, but then you made a new argument in your brief that even if it did apply, you can override it because you've got this plenary authority under 34-1504. Right? You did make that argument?
Yes, Your Honor.
Right.
And
how far does that plenary authority go?
I believe, Your Honor.
Can you ignore the Human Rights Act?
Of course not.
Okay, why can you not ignore the Human Rights Act? You can't discriminate at will in your regulatory capacity. So why can you ignore this environmental statute that was enacted after 34-1504?
Well, Your Honor, the environmental statute that we're talking about, the commission doesn't believe it applies. In reading the language of the statute.
Okay, that's going, never mind. Do you have any final comments to make?
The only final thing is that the commission would ask that you affirm their decision on both points.
Thank you,
Your
counsel.
Honor.
Appreciate your time.
Good morning, Your Honors. May it please the court, Nicholas Penn on behalf of the intervener, Potomac Electric Power Company, also known as PEPCO. I will try and speak into the microphone so you can hear me.
Thank you. We appreciate it because you do sound faint.
I do have a faint voice. Let me first, if I may, very quickly turn to the Benning Road issue, because there's been a lot of discussion with the court this morning about that. As I understand OPC's argument before this court, their argument is that section 105, the second sentence in 105, precludes any and all costs that relate in any way to the generation station that was formerly at the Benning Road facility. And respectfully, Your Honors, as you've read to us this morning, the language in that section doesn't say that. What it says is the Benning and Buzzard Point generation stations shall not be included in the cost of service for purposes of determining the company's District of Columbia jurisdictional revenue requirement. Your Honors, that station has not been in PEPCO's jurisdictional revenue requirement cost of service since 2000.
What does it mean? It sounds a little metaphysical for it to be in. So what do you understand? How would it be in if this isn't in? I mean, if it's true, which I know may be factually disputed, but if it's true that the investigation costs, remediation investigation, feasibility study costs at issue here may focus geographically on a part of this site where the generation station was located and may be connected causally to activities of the generation station. If that is true, you still think those are not, and if considering those, including those expenses in the cost of service, isn't putting the generation station in some sense? I'm just trying to figure out what gloss on the word "in," if that's the key word there, you're taking.
Yeah, and it probably would have been helpful in hindsight if that language in that particular section had been more broadly structured and worded. But the reality is that there's another code provision that was enacted.
Well, before we move up to another code provision, I'm not sure I got an answer to the question I'm asking, which is, you don't think, I gather, that the RIFS costs, apologies for the acronym, even if they are so in some sense geographically allocatable to where the station, where the generating plant was, and even if they're causally connected to the activities of the plant or both, you don't think including those costs meets that language because that isn't putting the station in the cost of service? If that's true, is that right? Is that where it runs up against the language?
That is correct, Your Honor.
And what do you have to do more than that to be in the cost of service?
Well, in connection with this particular and if we can sort of focus on this particular generation station, this generation station hasn't been held by PEPCO since 2000. By statute, it was required.
Why does that matter, right? We have a property, right, that seems to be environmentally contaminated, right? And the EPA did a report and said, we have real concerns about, chemicals found in the soil on the property and things leaching into the Anacostia River. And the district said, we're going to sue you, PEPCO. And so here we are, and you all agreed, right, to do remediation investigation, and the actual remediation to clean it up is years in the future, right?
Correct.
And so cleanup needs to be done on this site that was held by PEPCO or its predecessor for decades, if not a century, right? And where generation was done, right? And so the whole question is, what sort of pollution happened? What's there now? And what do we have to do about it, right? And I'm trying to understand why the 1999 settlement agreement that says, PEPCO, if you keep this property, you can't come back to us you can't come back to the consumers for stranded costs if you sell it. at a loss because it's a contaminated property and is going to need to have all sorts of cleanup under RCRA. Or if you keep it in connection with any PEPCO base rate proceeding in DC instituted after 2000, which this base rate proceeding on appeal is, the Benning Road generating station shall not be included in the cost of service. Right? I don't understand why the commission can read that language and just say that has no application here. Now, what sort of application might be subject to interpretation and further discussion and further factual investigation, but I don't understand why the commission can say that has no application. And that's what we're here to evaluate, the commission's decision, not OPC's argument.
Exactly. And Your Honor, respectfully, with respect to that first sentence, the issue of stranded costs is not just related to sales. I know that was mentioned in OPC's reply brief, and that was one of their arguments as to why the second sentence, if you read it the way they're reading it, would not subsume the first sentence. But stranded costs actually can be, the easiest way of dealing with stranded costs is to have an auction, and then they're set by the market based on an objective price. But you can also have essentially a battle of the experts in which the stranded costs are determined, and then they're built into the rates of the utility that is still holding the asset. And if you look at
I understand that, and I believe that to be true, but I'm not sure it. Again, stranded costs are not directly at issue here because they at one point they seem to have been a theory being espoused, but they're not now. So we don't have to directly figure that out. But it has been raised as if we're trying to read this provision as a whole, and you need to understand how the pieces fit together, and stranded costs are part of the piece. So understanding that could be relevant. But take everything you just said as true. It doesn't seem to me that even if all that is true, that the stranded cost provision would make, or I'm sorry, that the stranded, that the last sentence would make the stranded cost provision redundant. Is your point that all stranded costs would necessarily be costs in future rate making, and therefore, if you can't get any costs in future rate making, you really any cost at all, there's no need to have a separate provision about stranded costs because they would all be embraced by the last sentence. Is that your theory?
Correct, Your Honor. And that's in fact what the commission had argued in its brief, that if you credit OPC,
and is that part of the commission's reasoning? In its order?
No, Your Honor. It's as you've noted, the language in the order is not that extensive.
So if as we settled with your colleague, the commission order says what it says,
Yes,
should we move on to the statutory argument in the interest of time?
we shall do that.
Thank you.
Your Honor. Your Honor, with respect to the energy efficiency programs, the commission's determination below was clear that the commission believed that the statutory requirements set forth in the Clean Energy Act in 1877 4.07G did not apply to the particular program that PEPCO had proposed as part of its 1156 enhanced MRP. And specifically, Your Honors, that was one element within a much larger package that was designed to provide customer assistance. The purposes here are very different. When you look at the Clean Energy Act, it's designed to foster and enhance clean energy adoption in the District of Columbia. What the commission approved in the enhanced MRP in the 1156 proceeding was an element within a much larger package that was designed to assist customers who were badly hurt by the COVID pandemic. And
Yeah, I take all of that as true, but the issue is really whether the particular subsection here, G4, was intended to be a general protection for SEUs. Or whether the protection that was created was intended to operate only within the some narrower sphere. And I guess it just seems by its wording that it is intended, it's basically, look, if regulated utilities and the commission want to get into the energy efficiency business, fine, but they need to consult with the SEU first and either get approval from the SEU, or if that's not forthcoming, determine for the commission, persuade for the applicant, the commission, that there's not substantial overlap. And the wording of the provision, and it seems to me that arguably its logical function, all seem to more naturally suggest that it's a general provision, not somehow limited by the focus of some of the metrics that were being created in the other programs that the commission was set forth on.
well, I guess respectfully, Your Honor, I do think that the Clean Energy Act is applicable probably in most instances to energy efficiency programs. But as the commission indicated this morning, it has very broad authority in the sphere of setting public utility rates. And this language doesn't actually say this is the only vehicle by which the commission can ever, in any circumstance, utilize an energy efficiency program. And I think if you look at the entire package that was being proposed, this was a very small part of a much larger program that was being proposed, not to advance necessarily.
Is there a statutory argument? I mean, it just seems like you're saying, well, if we stick an energy efficient program into a bigger package of something else, we insulate it from review under this statute that seems pretty mandatory and requires you to go to the DOE and the SEU. And I don't see statutory support for that. I mean, I just don't know why it matters that it was part of a bigger package or not.
Well, I think
If it's an energy efficient program of any sort, it seems like it needs to be blessed by the DOE and the SEU first.
if you credit that particular reading of the statute, Your Honor, it would have been impossible then for PEPCO to have offered any energy efficiency program at the time, because the working group recommendations that are in G1 that are necessary to submit an application had not been reviewed and approved by the commission at that point. So essentially, there would be nothing that the commission could do as part of a program that was designed to help customers with COVID that happened to include a small component that had an energy efficiency metric with it. I think respectfully, Your Honor, given what was going on and given the commission's broad authority in this sphere of public utility regulation, it's not unreasonable to say that in an emergency circumstance such as this, it wasn't unreasonable for the commission to.
Did the commission articulate anything akin to what you just said to us at the podium?
It did acknowledge that the purpose for these programs, the customer assistance programs, was as a result of COVID. Yes.
No, I understand that, but your more technical point of there would not have been time to do these reviews and
No,
No.
Your Honor, it did not. I mean, one would have to look at the actual timeline for when these things were put in place. And respectfully, this argument came up on reconsideration, so there isn't as much information in the record as maybe on some of the other points that were before the commission.
All right, counsel, you were over your time, but we gave it to you willingly. So thank you very much. We appreciate it. And we'll hear now from OPC, just a couple of minutes in rebuttal, please.
I actually don't have much to say. I don't know that we need to rehash the Benning issue unless you have a specific question for me on it. With respect to the energy efficiency issue, I think I mentioned when I came up initially that I wasn't sure if the commission had made the notwithstanding argument. They did. It's in their brief at pages 32 and 33. We did not concede that there was no duplication. Actually, we testified to the contrary. There's a quote in our initial brief at page 17. It's in the joint appendix, the testimony at pages 1732 to 33. And a specific statement in the testimony is that PEPCO has not provided enough details to determine whether these programs are complementary or duplicative.
Do you have a response to the argument, if I understood it correctly, that was just made that other provisions in the statute, the clean energy statute, would have made this so cumbersome as to make this impossible to comply with both?
That argument was not, to my knowledge.
I understand it wasn't made.
It wasn't
but
made, and
If,
I'm
do you
sorry.
have a response to it
I
now?
don't. I
Okay.
don't have a response. I don't know how that would have been addressed. What I do know is something I think I said the first time I was up here was that the fact that this was an emergency, which I understand, actually, in my mind, made it even more important that these programs be shown not to be duplicative, because customers would be asked to pay for them. Keep in mind that PEPCO offered them, puts them in a regulatory asset, and earns their weighted cost of capital on them. It's not, this isn't it's not an act of corporate altruism, and that's fine. But helping customers in a time of need through a program that all customers will fund, will pay for eventually, it's very important that the process be followed. And in this case, it clearly wasn't. And the commission's answer was, we don't read it that way, but it's fairly clear how it's supposed to work. If the court has no further questions for me, I have nothing further. Thank you.
Thank you very much. Thank you, counsel, for all parties, and the case will be submitted. The third case we have on our calendar today is 21 CV 735 Santorini Capital LLC et al. Versus WFG National Title Insurance Company LLC et al. Counsel, when you're ready, if you could introduce yourself and let us know how much time you would like for rebuttal.
Thank you, Your Honor. May it please the court. My name is Joey Levitt. I am counsel for plaintiff appellants Santorini Capital LLC and SC Holdings PF2 LLC. I would ask to reserve 3 minutes for rebuttal. Your Honors, I described in my initial brief the potential conflict in the case law regarding which standard to apply for a motion for judgment on the pleadings. There seems to be case law indicating that it's more similar to a motion to dismiss for failure to state a claim under Rule 12b-6. And there's some case law that seems to indicate it's more similar to a motion for summary judgment under Rule 56. I believe that my briefing, in an attempt to save time, I believe my briefing on the 12b-6 standard would be sufficient to address that argument unless this court disagrees. And so with the court's permission, I would just proceed on to the arguments surrounding if it's more similar to a Rule 56 motion. Your Honor, one case in particular, and was cited by a defendant, I think is particularly telling on the issue of what the standard is if it's considered to be more closely related to a Rule 56 motion for summary judgment. That's Murphy v. Department of the Air Force. It is a federal case. However, it's interpreting the analogous Rule 12C of the Federal Rules of Civil Procedure. And it just lays it out very nicely. It says the Rule 12C burden is substantial. If the Rule 12C movement cannot show both that there is no material dispute of fact as reflected in the party's pleadings, and that the law is such that the movement is entitled to judgment as a matter of law, then the motion for judgment on the pleadings must be denied. With regards to the issue of whether there's a genuine dispute of material fact, Anderson v. Liberty Lobby, that's a Supreme Court case from 1986, defines what a material fact is. It's one that may affect the outcome of the claim. I would submit that the material facts in dispute here are whether or not there is a covered risk, whether or not one of the exclusions applies, and whether or not prior written consent was obtained before settling.
How, if we're applying a Rule 56 type standard, which I'm not entirely sure we should, but if we were, how is there a material dispute of fact as to whether there was written consent obtained? I understand there's a waiver issue, but on the question of whether waiver was a written consent was obtained, the answer denies that. And I don't see any factual material that was presented by your clients to show that written consent was obtained. So if I don't see how you could win under a Rule 56 standard on that issue.
Yes, Your Honor. In the opposition to the motion for judgment on the pleadings, there was an exhibit presented by plaintiffs of a list of emails. And that does appear it was considered by the court.
I saw that, but
Yes.
I didn't see that any of that indicated that written consent had ever been provided. It's more relevant to whether a written consent, if required, was waived. But I didn't see, you could point me to something in those emails that would be something on which a reasonable fact finder could conclude that a written consent in fact was obtained. Is there something in there that?
Well, Your Honor, essentially, I would admit that the emails do not expressly provide written consent in those emails alone. However,
What else do we have besides them?
and I'm sorry, I don't mean to interrupt.
No, that's fine.
The emails suggest that defendant was not only aware of plaintiff's negotiation with the bankruptcy trustee, they were kept apprised of development in these settlements discussions, both by email and phone. Further communications also show that defendants denied coverage based on there being no compensable loss, and they did not mention that settlement with the bankruptcy estate was the issue in denying. To the extent that there is no conclusive proof that written consent was obtained.
Well,
There's
that's not the summary. The summary judgment standard isn't a conclusive proof standard. It is, if one party points to evidence suggesting that there was no written consent and the other party doesn't identify any that indicates that there was, even if there's no conclusive proof, summary judgment might well be warranted. So I'm not sure where the conclusive proof phrase is coming from. And I'm still, your opponent sees those emails so differently as to say that they actually constitute in effect an admission that there was no written consent. I don't know if I go that far either, but I'm not quite sure that anything in them or anything else you said yet would permit a reasonable fact finder to say, oh yeah, I believe there was written consent.
Your Honor, and I take your point. I would agree that the emails do not at all rise to the level of an admission that no prior written consent was obtained. But my point essentially was that there is neither proof of express written consent or proof of refusal of express written consent. Therefore, there would likely have to be an inference drawn from the emails. At this stage of the proceedings, under a motion for judgment on the pleadings, any inference must be drawn in favor of the non-moving party, which would be the plaintiffs. Therefore, that's how I'm arriving at the conclusion that a reasonable jury could find.
Have you ever actually, you personally, obviously, is your client ever actually claim that written consent was provided? Is that an identified dispute of fact? I know that there have been arguments that were in the nature of, it hasn't been definitively shown that there was no written consent, but I don't recall having seen a clear statement. It's certainly not in the complaint, but in the opposition to the motion for judgment on the pleadings, I don't remember, nor in your briefs in this court, where you're not in a position to be making factual assertions anyway. But I didn't see any factual assertion saying, oh, no, we contest factually. There in fact was no written consent. We claim there was no written, that there was written consent, excuse me.
Yes,
I
Your
just
Honor.
haven't never seen that claimed by your client.
I believe the farthest that the opposition goes is mentioning that the emails can show that it may rise to the level of tacit consent. With respect to the issue of particular written consent, I do not believe that there is a specific claim that prior written consent, we certainly contest that prior written consent was obtained. However, I would, yes.
If the emails, if the assertion is that the emails show tacit consent, but the agreement says you don't have coverage unless you have written consent, is that effectively an admission that there's no material dispute of fact here? I mean, I'm not. Now, I take your point, there's nothing in evidence yet, but I come back to Judge McLeese's question of, is this really even an issue, right? Because you need written consent.
Correct, Your Honor.
And I don't see anything in the record where you have ever claimed that you had written consent before entering into the settlement agreement. And in fact, the emails strongly suggest much to the contrary, where there's an email from July saying that you or your client has talked to the bankruptcy trustee, sort of seemingly persuaded the bankruptcy trustee that you're a good faith purchaser for value. And so you're sort of hopeful that things are going to work out, but nothing is set out in any detail. And then there are emails from Appalachia saying, can we get an update, right? In July and August and September and October, I think. And then finally, in response to the last inquiry of, can we get an update? That's the first time that there is a communication about an already occurred settlement agreement. So I'm hard pressed to see how one could claim that there was prior written consent, but I also I don't see that has ever been asserted. So are you sure that that's a material issue of fact that remains to be decided?
Your Honor, we would submit that it is. I would first like to address if the court is not persuaded that it is.
On what basis are you saying that it remains?
Yes, Your Honor, excuse me. In reading the emails, and again, in viewing them in the light most favorable to the non-moving party and on the reasonable inferences therefrom, the combination of I think you mentioned the July email where there's the discussion regarding essentially what to do with the bankruptcy title issue. And then further, when asking to contribute to the settlement, the response of the defendants is that there's no compensable loss and doesn't mention you did not get our prior consent. That combination of emails and the inferences therefrom drawn in the light of
support tacit consent, but you need written consent. So I'm just trying to see where it is in the record that supports you and a contrary assertion that would create a material issue of fact that prior written consent was in fact provided.
Your Honor, our position is that the emails and the inferences that are drawn therefrom could support that, or a reasonable jury could find based on.
There was prior written consent.
Correct, Your Honor, yes. And I would mention again, if the court is not persuaded on that fact, I would urge that does not end the issue, because there is the separate issue of the other $125,000 in expenses. So that while the motion for judgment on the pleadings, if the court agrees, had been correctly granted with respect to the settlement issue, there is still the issue of the $125,000.
Can I ask you, I thought it also might not end the issue because you had an alternative argument, which was even if written consent is required under the policy, it was waived through the conduct, that requirement was waived by the conduct of the insurer.
Yes, Your Honor, that was an argument brought in the opposition.
I have the recollection though, as I'm sitting here, I'm not sure that you made that point in your brief in this court too, or did you not make that point in this court?
I do not believe that I included that in the briefing to the court, but it was included in the opposition on the motion for judgment on the pleadings.
So if you did not brief it to us, is it waived at this point?
Without conceding it may be, Your Honor. I don't want to concede a point I'm not ready to concede, but there potentially yes. Your Honor, turning to the other $125,000 in expenses.
Can I ask you first a factual question that might relate to all of this too?
Mhm.
In the answer, one of the defenses was recovery is barred under, I think it's exclusion 6, because this is a defect in title, if it is a defect in title that resulted in no loss or damage.
Oh,
And so that's one of their defenses.
yes.
And in support of that defense, they have an attachment which are attachments that reflect a sale of the property, and their assertion in their answer is that the property was sold in an amount that permitted satisfaction of the entire loan amount. Do you dispute that? Do you concede it? What is your position with respect to that factual assertion in the answer?
Your Honor, the factual assertion that no loss or damage was sustained, we do dispute.
Well, no, but
I'm sorry.
that's not purely a factual question. That becomes a question that has legal components about how to interpret the phrase loss or damage in the contracted issue.
Yes, Your Honor.
But on the question of whether the property was sold in an amount that permitted complete satisfaction of the loan amount specified in the loan title insurance policy, do you dispute those historical facts?
Your Honor, I believe, and I don't want to contradict myself on the briefings. I believe in the briefings I did mention that on the overall sale, a profit was made. I think that would sort of infer that the loan was satisfied. However, what I have noticed is that the payment for the foreclosure proceedings, the payment for the property on the foreclosure proceedings, which is mentioned in the emails as being $135,000, was not considered by the court or defendant in the calculus of whether or not a profit was made upon the sale. And I believe the profit discussed was $58,000, a little over $58,000. And so should there—
Well, again, you're using a bunch of other concepts. My question is a little narrower.
Okay.
So let me put it this way. Maybe this will simplify, maybe it will complicate, I don't know. The gist of the answer and its attachments is the property was sold at an amount that permitted full satisfaction of the loan amount on the face of the title insurance policy. Leave aside other profits and all sorts of other things, but do you dispute that historical fact, which is that I forget what the number is, 128,000 or what the number that's on the loan insurance title policy is, the amount of the loan that was covered.
299,000.
I don't know where 299,000. Do you dispute that the property was sold for more than that amount?
And again, this is where I get into. I believe in my reply brief, I don't dispute that fact, but I think I did fail to mention the discussion of the foreclosure proceeding. So I believe, again, based on my briefing, I would not be disputing that. However, I don't think that affects the bottom line of whether or not a damage or loss has occurred.
And that gets you to a question of how to interpret that
Yes.
language. And I gather from your briefing, you're not aware of any legal authority. I mean, these title insurance policies have recurring provisions. And so there's law around the country about a lot of these recurring exclusions and what phrases like that mean, but you're not aware of any such authority on that.
No, Your Honor, at least I haven't been able to find any. The plain language of the contract does explain that it protects against or insures against loss or damage not exceeding the amount insured, which would be not exceeding $299,850. And the loss or damage would have to be by reason of one of the covered risks. I can recognize the trial court's potential confusion when using the word loss, because when viewed in conjunction with the word profit, it does appear that profit and loss may be opposites. I would submit the plain meaning of loss does not preclude or does not indicate that if you make any profit, you have suffered no loss whatsoever. It's a compensable monetary harm or pecuniary injury.
I'm trying to figure out what you do mean, and you just highlighted the language in the agreement saying that it protects against loss, not exceeding the amount of the insurance. So are you essentially saying that by purchasing this policy, you got, let's say I can't do math, so $299,850. Let's just call that $300,000. Let's say you wanted to get $600,000, which is the actual cost of the mortgage plus not exceeding the cost of the insurance, which was $300,000. Are you saying that that's what you were entitled to, but no more? Is that your understanding of loss?
I'm not sure I understand the reference to $600,000. How that, I don't want to answer the question.
You were highlighting the language in the agreement saying that you're entitled, you've insured your investment against loss or damage not exceeding the amount of the insurance.
Yes.
So it seems like you're saying like you get $300,000.
No, Your Honor, no, I'm
Okay.
not saying that. I'm highlighting that.
What
yes.
is your understanding of loss? If your understanding of loss is not what the trial court thought it was, which is, look, if you got your money back, everything you bargained for, you haven't lost anything. What's your definition of loss then?
I'll first state that the reason I'm discussing the not exceeding the amount of insurance, just to point out that the $167,000 in claim damages is less than $300,000, which is what we were insured and what a defendant agreed to protect against.
Right, but that just gets me back to my hypothetical, right?
Okay.
Because you've conceded that you sold the property for far more than $300,000. You've conceded that you sold it for $500,000, right? So I'm just trying to figure out, are you saying that you're entitled to the amount that of the mortgage plus $300,000 because you insured it against loss not exceeding the amount of the insurance? What's your understanding of loss?
I am saying that we are entitled to receive the actual, the harm that we suffered, the $167,000, and that fits within the policy limits.
So help me with this.
Yes.
This policy says loan insurance up top.
Mhm.
Does this policy protect you from loss on the loan? Or is it that this, rounding it up to 300,000, is just a pool that you can pull from for any loss related to the property?
Our understanding of the plain language of the contract is that it insures against loss or damage caused by defect in title. The $300,000, which yes is equivalent to the mortgage amount, is simply the amount of insurance.
So just to take a hypothetical, imagine that I am an individual and I take out a loan title insurance policy with this language, and there's a title defect, and it's very upsetting to me. And I end up, suffering psychological, I have psychological suffering, and I would like to prove damages. And maybe I even have some costs. I have to go. I literally seek therapy legitimately, and so I get some. I spend some money on that. Ultimately, that title defect is cleared, and the property is sold, and they recover my entire loan amount. You're saying that doesn't matter. There was a title defect. It had adverse consequences to me, and I can recover under notwithstanding this exclusion, which I think is 3C. I think I said 6 before.
Essentially, yes, Your Honor. I don't know if I want to go as far as psychological harm, but I think in our specific factual instance, we have actual costs that, but for the title defect, plaintiffs would not have incurred. They had a contract for sale. That contract was terminated based upon the title defect, and the carrying costs that ensued were directly related to that title defect. So if I were a title insurer, I think I would be pretty unenthusiastic about insuring people to thinking that my loan title insurance policy isn't to say to the person who's taking it out, however much money you loan, you're going to get it back.
we, because, that would, assuming it's a result of a covered risk, that will cover. But the idea that sort of lost profits or out-of-pocket expenses, even if you get all the money back, so it's all sort of lost profits. We'll kind of be an insurer of any consequences that reduce the profits that you otherwise might have gotten in the world. I'd be pretty leery of insuring that. I have to say, it seems like not the most natural thing you would think that a title insurer would understand was being insured. And it's fair to say you're not aware of any court around the country that has interpreted the language the way you're suggesting we should to permit recovery, notwithstanding this exclusion, even if the loan is fully paid off.
I would, the reason I would push back is that I believe the plain language, again, I have not seen in the contract a provision stating that if your loan is repaid, there is no damage, and defendant has not pointed to a provision in the contract stating that. The plain language of the contract states it insures against loss or damage caused by a defect in title, and that loss or damage cannot exceed the amount of insurance. And so in that sense, that the plain language of the contract clearly fits this, the harm and the expense suffered by Santorini and SE Holdings, PF2.
Well, you say plain language. I guess one question, it seems to me less plain, not so plain, because in a way, one way of looking at the potential ambiguity in the language is whether it's net loss or loss measured against what. So you loan some money. If you don't lose any money that you loaned, then there's no loss. That's one way of reading the language. On the other hand, another possible way, for sure, I mean, I agree with you that it's not, your theory is not unambiguously foreclosed by the language of the provision. That seems to be true. Would be to read it to say, it doesn't matter, even if you're made whole with respect to the amount you loaned, if you suffered other losses, those are cognizable. So kind of individual loss, even if there's no net loss. It just seems like the language is somewhat ambiguous.
Now, our position, I think, is that it's unambiguous in favor of us, but I take your point that there could be ambiguity. If there is, a standard contract interpretation principle is that the ambiguous language must be construed against the drafter, which in this instance is.
Also, I think there may be, this is just vague recollection, but I thought there were also some provisions about construing insurance policies in favor of the insured.
Yes, Your Honor, that is cited in our opposition in the motion for judgment on the pleadings. I apologize, I don't have the case name, but yes, that it's construed against the insurer. And again, the thing here is that loss and damage are not defined in the contract. When they're not defined in the contract, they must be given their plain ordinary meaning. And we have cited to both in our, I believe in our reply brief and in our motion for opposition to the motion for judgment on the pleadings, plain definitions for loss and damage that are monetary harm, pecuniary injury that is measurable.
Let me ask you about that in plain and ordinary and measurable. You get insurance at the time of insurance, and most standard insurance policies cover the value of something. I have homeowners insurance and I can't get more than the value of my house. If I was it has become popular with college athletes to get draft insurance now, which is a speculative kind of insurance. And they have specific language about the speculative nature of that. Why would we not look at a contract like this for insurance and look for specific language protecting something speculative like your profits, as opposed to protecting the value of the money that your client put out?
I think I understand your question. I'm not sure that any such language exists in this policy, or at least not that I have seen or been made aware of by any other by defendant or by the briefings. I would say that if that sort of language is not included in the policy, then it should not be considered.
So you're saying that we shouldn't see if the policy itself doesn't say profit insurance, we shouldn't read profit insurance.
Oh, I'm sorry. I think I must have misunderstood. I think the plain and ordinary meaning of loss or damage encompasses. I can see how it's being framed as lost profits, but it's essentially it's an expense incurred as a result of the defect in title.
Can I just, this is another hypothetical, and it may not be that different from the one I asked before, but it somehow seems a little more realistic and concrete. I don't know, maybe they're equally unrealistic. But assuming that as during the process of trying to work out the bankruptcy issue, the principle of, imagine a simpler case than this, and it's an individual who took out the policy, and the person, ends up driving somewhere to meet with someone that has a car crash and ends up having, $300,000 in consequential damages, medical injuries and damage to the car and all that, or $299,000. Your view would be recovery of those amounts under this title, this loan title insurance policy, even if the loan is fully paid out, because as a but-for result of the title defect, there was loss suffered by the signatory who was insured under the policy.
That may get into a question of proximate cause, Your Honor. I'm not sure if I'm.
Which could arise here, though. Nobody's teed that up because there's a kind of a chain of events about how it is that Santorini Capital is even in a position, or SC Holdings is even in a position to make any profit off any of this.
Well, Your Honor,
But yes, I take your point. It could
Yes.
be an issue of proximate cause.
Yes,
But your view is barring, if that's approximate, otherwise it's covered. If it's not covered, it's because there is an implicit limitation on damages that are not proximately caused by the title defect.
I believe the answer to your question, I would say is yes, I believe that's correct.
I have one last question, and I think I'd like to hear from Apali. Does it matter that the documents themselves are talking about an insured mortgage? They're not talking about insured profit loss or what was insured here was the mortgage, and the mortgage was $299,850.
Yes, Your Honor, I would again fall back on the plain language of the contract stating that it insures against loss or damage caused by the defect in title. I think it is certainly reasonably foreseeable that a lender would foreclose upon the property and then become the owner of the property and could suffer damages of this.
But that
this type.
goes to the mortgage, right? I mean, that's why you might have recovered the $42,000 if proper consent were given before the settlement, right? That seems related to, any loss related to the mortgage. If you don't get your asset, right, then you don't have it to sell, and then you're out of pocket on the money that you lent, right?
Correct.
Right. You insured the mortgage.
Yes, Your Honor.
You
but
didn't insure your future profits on the property.
Again, I think the discussion of calling it future profits, it may sort of, and with all due respect, may sort of muddle the issue a little bit. The point of the matter is that it is an expense that was incurred by the insured as a result of a title defect. And I don't know if we need to get into a deeper discussion of proximate cause or whether or not that was reasonably foreseeable, but I certainly would submit that on that issue, there would be a genuine dispute as to material fact, and a motion for judgment and pleading should not have been granted on that issue.
Well, I mean, an expense and a loss are somewhat different. I mean, if I have an expense, but then as part of a process, and at the end of the process, I get that expense and more, I don't think people would, if you're looking at the process as a whole, I don't think people would say I suffered a loss. I had an expense, but I actually had a profit.
Yes, Your Honor, I agree. And that's why I think the word loss, again, when used in conjunction.
Well,
with
I was just
profit-
getting hung up on the word expense because
Okay,
I do think.
yes,
to
so
say that
I
it
should
was-
use the word damage. I'm sorry, because that is,
Well, but I mean, this shows to me at least the arguable ambiguity of all of this. You are pointing one way of looking at the way the trial judge and your opponent look at it is you may have had some expenses, but you had no loss because you netted out in the black. So where's your loss? That's the way. That's one way I think of conceptualizing. That's not the way they worded it, I think, but that's one way of conceptualizing their thinking.
yes, Your Honor, the calculus employed by the trial court of what was the mortgage, what did the property sell for, what were these expenses, where's your profit, does not take into consideration everything necessary for such a calculus of whether or not you suffered harm. I think exclusion 3C specifically would relate to a situation where, for instance, imagine the initial contract for sale that was canceled was for $500,000 or $525,000. Then after expending the money based on the title defect, a new contract was entered into for $5 million. There is certainly an argument there to say that you did not, or you were benefited by the title defect. You did not actually suffer any harm regardless of the expense. That was not the calculation employed by the trial court. That's not the calculation employed by defendant. They're simply discussing whether or not there was a profit on the eventual sale. And we submit that that's not the correct calculus to make and not the
I
correct way
don't think
to.
they're asking whether there's a profit. I think they're asking whether you got the money that you lent back. Right? Because all you insured was the mortgage, right? You lent $300,000 to Santorini and you insured that to make sure that you got that money back. And there was not an agreement to insure anything other than the mortgage, right? That's what these documents say, is that you insured a mortgage.
Your Honor, the documents say that it insures against loss or damage.
Insures a mortgage against loss or damage. I just think you're missing a key term in the documents, but we've had you up at the podium
Yes,
for
sir.
quite a long time, unless one of my colleagues has a follow-up question.
I mean, I have a very brief one. We haven't used it we haven't discussed it in these terms yet, but as a party to a contract, any contract, insurance or otherwise, you have a duty to mitigate. Mitigating your damages is always going to involve some expenses. In that analysis, regularly the court has looked at and taken the expenses out of what the party ultimately got. How is it any different here? You mitigated and came out on top of your expenses.
Well, Your Honor, that's a point we dispute, that we came out on top, regardless of the profit, we still suffered a harm. I
understand, counsel. We're reiterating the same point. I've
yes,
got
Your
you.
Honor, and I don't intend to waste.
No, and I appreciate that my question set you up.
Your Honor, I would say that.
We're going to give you another few minutes for
Okay.
rebuttal. So why don't you go ahead
Yes, sir.
and let Appellee take the podium and we'll hear from you in a minute.
Thank you.
Thank you.
Thank you. May it please the court, Robert Gill for the appellee, WFG Title Insurance Company. You put your finger right on it, Judge. There's a major distinction in title insurance law between a mortgage or loan policy and an owner's policy. A loan policy only insures the deed of trust or mortgage, nothing else. An owner's policy might insure the policy in terms of the value of the property, but even that's not going to ensure profitability. No title insurance policy I'm aware of insures profitability.
Can you point us to where in the loan agreement it supports what you're saying? I mean, I'm looking at page 30 of the appendix that
Right.
identifies the amount of the insurance. This is Schedule A and the mortgage amount, and they're the same. And then it says the estate or interest in the land identified in this Schedule A and which is encumbered by the insured mortgage is fee simple and is at date of policy vested in the borrower, shown in the insured mortgage and named above. Right, land referred to this policy is described as set forth in the insured mortgage. But I don't see sort of the affirmative statement of we are insuring a mortgage, right? There are these references. And so I just wonder if there's more that I'm missing.
Well, if you look at the policy makes clear that, for example, if you look at under exclusions from coverage, which are in the appendix on page 24, where we're talking about, for example, the claim brought by the bankruptcy trustee, which is the exclusion number 6. A claim by reason of operation of federal bankruptcy, state insolvency, or similar creditors' rights laws that the transaction creating the lien on the insured mortgage is a fraudulent conveyance. So
Yeah, that's not quite the affirmative language, right? That's
It's-
in the
you're-
exclusions. I'm just looking for sort of the one clear affirmative statement of
right,
this.
I know, I
is the-
understand your point, and by my limited time, I'm happy to submit anything you like and following up on this, but this policy is, I mean, if you look, for example, at the bottom of every page of the policy that's in the appendix, you'll see it says at the very bottom, and a footer, Alta short form residential loan policy. So that Alta is the American Land Title Association. So this is a form policy that's used by various title insurance companies to insure mortgages.
My sense was that from looking at treatises and research is that a number of foreign policies like this actually take the trouble to define terms like loss and damage, but
Some do.
that seems like it'd be pretty desirable.
Well, I agree with you, but I think the cases that construe these policies though make it clear that where you
What
have,
cases are you referring to? Because I didn't see any cited in the trial court or this court.
well, generally speaking, though, the only coverage is provided for a loan policy is for the insured loan.
I'm just asking you, you're referring to cases. I'm just wondering.
Right. Well, just generic cases, that talk about the nature of the insurable interest in the policy. Insurable interest in an owner's policy insures one's ownership property in the property at issue, whereas the loan policy only insures the loan or mortgage.
Well, if there were cases that would be helpful, it might be nice to have you submit a 28K letter with those cases since they weren't in a brief.
All right.
Can I ask you a framework question? This is where your opponent started, which is in deciding the issue in front of us, should we be treating this like a 12B6 motion to dismiss, or do you think we should be doing something that is more in the nature of summary judgment ruling?
And that was kind of an interesting issue to me. I frankly don't understand the argument as applies to this case. We didn't argue that the complaint was insufficient, that the allegations that were made in the complaint were so vague they were not plausible.
Well, let me tell you why. Let me make the question concrete.
Sure.
So the two theories on which the trial court ruled in your favor, one of them that there was no written consent,
right,
and the second that there was no loss because there was a sale, in greater than the loan amount, so there would have, the debt would have been fully satisfied. Both of those depend on facts that are not in the complaint.
Right.
Complaint. I think you suggest that the complaint may implicitly allege, may concede one of them, but I think that's difficult. So let's just take for a minute. They're not in the complaint, I don't think.
Well, actually, with due respect, Judge, I mean, they admit in their brief on page 4
Well,
of their
leave
brief.
aside I'm talking about the complaint.
Okay.
So we can talk about other phases of the proceeding, but let's just talk about the complaint for a minute. Take for it as a given that neither of those two facts has admitted the complaint. They're both alleged in the answer.
Right.
By operation of the rules, our rules are like the federal rules on this, those are denied because there's no opportunity to respond to an answer. So those are denied by operation of the rules by your opponent. Now, then they're reiterated, those facts are reiterated in the motion to dismiss, and your opponent files an opposition to the motion to dismiss.
Right.
If you're really strictly applying the Rule 12B standard, it's not so clear to me that anything that's in the opposition to the motion to dismiss, which is not in the pleadings, should be considered at all. And so it gets tricky. It makes a difference whether we're really considering only, as we would under 12B type settings, unless we're converting to a summary judgment motion, considering only what's in the answer and the complaint in the answer, with anything in the answer being denied, or whether we can consider things that either weren't contested or were conceded later on. So I think it could make a difference to how to resolve this appeal. That's somewhat theoretical or seemingly arcane question.
Well, I would respond to your inquiry this way. I think I'm not aware of the cases that really provide the analysis on a particular issue, but as a practical matter, we were the movement, we filed a motion, they responded to the motion. I think it was incumbent on them to try to controvert the allegations that we made in the motion, whether they're legal arguments or factual.
Well, they did
assertions.
controvert them. This is not 100% clear, but I understood them to be saying in part to controvert them in part on legal grounds and say, this is a motion for judgment on the pleadings. It's too early for that. They're asserting facts, but they're not in the, it's too early to be getting into facts. All you can look at is what's, you got to look at the facts in the light most favorable to us. And those facts aren't in the complaint, and maybe they're alleged in the answer, but so what? It's not time to be deciding facts. So they controvert them procedurally. I agree with you that they don't controvert either of them factually. I'm not sure they affirmatively concede them, although at times they come kind of close. But they don't, so I agree with you, they don't controvert them factually, but they do controvert your motion for judgment on the pleadings on procedural grounds, saying, look, it's too early for that.
Right.
They're relying on facts that are in their answer. And so why are we going to be granting judgment on the pleadings based on facts that are in an answer?
Right, but under the rules, of course, it wasn't premature. Motion for judgment on the pleadings.
Well, no, it's not
proper
procedurally
pleadings
premature,
clause.
but I think they are I think their point seems well-founded that unless you're converting the Rule 12 motion to a Rule 56 motion, any facts that are in your answer are treated as denied, so they couldn't be the basis for a ruling in your favor.
Well, I disagree. I think for example, I attached to the answer a copy of the trustee's pleading that attacked the validity of the conveyance of the property to the plaintiff. And that became part of the record. If they didn't like the material that I attached to the record, it was incumbent on them to move to strike and have that excluded from the record. It wasn't.
Why do you say that? Like, what in rules or case law?
But well, because the rules say that when I attach something to my pleading, it becomes part of my pleading.
Well, for sure, it's part of your pleading, but
Right,
the point is that by operation of the rules, they denied it.
Well, they
And
did.
that's our Rule 8.
Actually, they did. The attachment to my pleading was the trustee's motion. They discussed the trustee's motion in their complaint. And then I attached a copy of the motion to my answer. So they didn't, dispute it. I mean, they conceded the existence of the document. I made the document part of the record, but they expressly admitted in their appeal brief on the very top of page 4, where they said, after resolving matters with the trustee in the bankruptcy court, Santorini requested that WFG make a contribution to the $42,000 payment to the bankruptcy trustee. That's on top of page 4 of their brief.
Yeah, that's actually not literally a concession that they hadn't previously gotten written consent. It just says after it happened, they asked you for the money. But I agree, it strongly implied. I mean, I'm with you almost to the point of them conceding it. They didn't contest it, and they say some things that are pretty close, both on that and on the sale amount, for sure. But just back on the rules, I mean, our Rule 8B6 says an allegation is admitted if a responsive pleading is required and an allegation is not denied. If a responsive pleading is not required, an allegation is considered denied. And there is no responsive pleading to an answer. So I think they, by operation of our rules, denied the facts that are in your answer.
Right.
So then how can we have judgment on the pleadings on a factual matter that's been denied unless we need to, I mean, you can't take as true a fact that is attached to an answer and has been denied. That would be a summary judgment kind of ruling down the road. So
I respectfully disagree with you on that. I mean, so for example, I attached the trustee's submission to my answer, which expressly implicates exclusion 6 under the policy. So exclusion 6 under the policy, which they dispute, they controvert it, but nonetheless, exclusion 6 says that it excludes coverage for any kind of claim of a fraudulent conveyance under the bankruptcy laws of federal government or the state. The trustee's motion was exactly that. That's why I attached it to my answer. That was the basis for the trustee's claim. That's what was settled. So the trustee's claim, they're contesting the truth of whether or not the trustee was correct. That doesn't matter under the policy. The policy excludes a claim based by, for example, the trustee. That trustee asserted that claim, said this was a fraudulent conveyance. They settled the claim. So the claim was not a covered claim under the policy. And when they settled it without our consent. And that seems to be pretty well established. There's no written consent. And so, that's not covered under the policy. They failed to show anywhere that there was a loss of the mortgage. If they had showed, for example, that, look, we bought a property for $1 million and we insured it, we put a mortgage on it for $500,000. And because of a defect in title, we could only sell the property for $250,000. And therefore we had a $250,000 loss for a mortgage. Well, then you stated a claim for a loss under your mortgage. But where the mortgage has been paid in full was tacitly admitted here, to use the appellant's language, tacit admission. So the sale was $525,000. The mortgage was paid in full and there was surplusage. They're just unhappy because the sale was not more profitable than it was, but they admit it was profitable. And they admit, they say, well, we had additional
Well,
expenses.
where
we
did they
had-
admit it was profit? Where do they admit, or do you mean tacitly admit?
Well, the trial judge found that they admitted based on the record below, and I think that's true.
The trial court found that they admitted it? I don't remember that. Now, maybe I'm forgetting something.
The trial court in its ruling,
The trial court found that to be the case, relied on it as a fact. That's a different
Right.
thing than you were saying your opponent has admitted that fact. And I didn't think they quite got there, although I know there, maybe I could see you saying tacitly admitted, but if you think it was actually
I think we're,
explicitly admitted somewhere, it'd be great if you would point me to where.
well, they've admitted the property is sold for $525,000.
Where do they explicitly admit that?
I'll point that out to you as well, if the court please.
Well, we can, I mean, the materials aren't that extensive, so if it's there, we'll find it. But I'm not, I will say I'm not aware of that ever having been explicit.
Are you
But-
talking about admissions in court today or?
Well, and admissions in the briefing too. I mean, they admitted that the sale of the property produced $525,000. So it's for litigation purposes, it's not a disputed fact. I think they're judicially stopped from coming back at this point and saying, well, that's not in fact true. The property was sold for $525,000. The mortgage was just $300,000 effectively. So there was no loss in the mortgage. They're complaining that the sale was not more profitable than it was. They're complaining that they had to have carrying costs. They had to pay, for example, real estate taxes on the property. They wanted to renovate the property and spend expenses for that, but they still made some profit, just not as much as they want. And this policy, nowhere in this policy does it ensure profit. It only ensures loss. And even then, it's not a pool of money that's used to offset any loss that you might suffer with regard to the property based on your ownership of it. It's only going to take care of the loss with respect to the mortgage or the deed of trust. It doesn't go beyond that. To go beyond that, you need an owner's policy in order to be able to reach your right as an owner. But even then, an owner's policy is not going to ensure profitability when you want to sell it. So that's where we are. So we have exclusion 3C, which is an exclusion where there's no loss to the insured. We have exclusion 6, which excludes any claim based on fraudulent conveyance laws of the states or the federal government, which was exactly the trustees' claim here. That's why I attached that motion by the trustee as an exhibit to my answer. They discuss it and they actually address it in their complaint as well. And they admit what happened with regard to the trustees filing, and that expressly falls within exclusion 6. And then there's section 9 of the policy that requires that they obtain written consent. And I think it's uncontroverted on the record that no written consent exists.
Thank you, counsel. We appreciate your time.
Thank you very much.
Your Honors, I don't think I have too much in the way of rebuttal. I take Judge Easterly's point in the discussion with opposing counsel regarding the use of the term insured mortgage in the contract. However, I don't think that even when read as a whole, that defeats the plain language of the contract stating that it insures against loss or damage. And again, the discussion keeps coming back to loss, but there's also that terminology of damage. And the plain meaning of loss or damage encompasses the expenses incurred by plaintiffs as a result of the title defect that is under one of the covered risks. I realized also, Judge Howard, I did not get a chance to answer your question about mitigating damages. I don't believe that there's been an allegation that plaintiffs failed to mitigate their damages. And it's certainly well within the realm of plausibility and well within a reasonable jury's purview to find that the expenses that they incurred were as mitigated as possible. That potentially, if they didn't mitigate, they could have been more, something to that effect. That would be my response to your question earlier.
That your client was successful in mitigating.
Yes, Your Honor, and that the mitigation resulted still in those expenses that they incurred, and perhaps a reasonable jury could find that there could have been more if more evidence is presented. I believe that's all I have in the way of rebuttal, unless there are other questions. Your Honors, I would just ask that you reverse the ruling of the trial court and remand for further proceedings in accordance with that determination.
Thank you, Mr. Simmons. Thank you, Mr. Gill. We appreciate your time and thank you for being last in line. I know you had to wait quite a bit. The case will be submitted and we stand adjourned. Thank you.
All right.